Hear, all persons having business with the appellate division. Draw near, and shall be heard.
Elizabeth? Good afternoon. Welcome to the Appellate Division First Department. Oral arguments for today, November 17. This sheet says there are almost 8 hours of argument time requested for Thursday, November 17. Okay, so we know that's not happening. So therefore, we will proceed. So let me just again state, we've read your briefs. We are totally, fully aware of your arguments. So please, only request the time that you need to make your arguments, not the time that you want, but the time that you actually need for your arguments, okay? People versus Stephen Baylor.
Good afternoon. Appellant requests 5 and 1 for rebuttal.
5, 1, and 5. Burdell versus Federal National. That matter is submitted. Rivera versus Shea.
Appellant requests 5 minutes and 2 minutes for rebuttal.
5, 2, and 5. Davis versus Brown. 5, 2, and 5. Federal Insurance versus Lester Schwab. 5, 2, and 5. McCartan versus Shea. 5, 2, and 5. People versus Alonzo Johnson. Do we have a yes? 4, 1, and 4. We might have to break the mold a little bit there. We were too many 5 and 2s. Holmes versus the City of New York. Okay, so we have 5 and 2, 5 and 2, 3. You have a cross claim, counsel? You have a cross claim? Yeah. Oh, okay. So 4 and 1 for you. Does that add up? Yeah? It adds up. 122 East 42nd Street versus Shaft. 5 and 3? Okay. 5 minutes? Okay, that case, by the way, is going to be called first because Justice Friedman is recused on that matter. Melikov versus 66 Overlook Terrace. 6 and 2, and you requested how many? No, how many? What time did you require? 2 minutes. 6, 2, and 2. 199 versus New York City Loft Board. 5, 2, and 4. And 4. 5, 2, 4, and 4. People versus Fernando Rodriguez. That's 2 matters. We'll hear them both at the same time, and they're both submitted at the same time. Thank you. Meadow Apartments versus S&H LLC. 5, 2, and 5. Children's Magical versus Marham. 5, 2, and 5. Schumann versus New York Magazine. 5, 2, 5. Nostalgic Partners versus New York Yankees Partnership.
The appellant requests 7 minutes and 2 for rebuttal.
5, 2, and 4. First matter for argument is 122 East 42nd Street versus Schraff. Again, Justice Friedman is recused. Justice Pitt is vouched in. Whenever you're ready, Mr. Catterson.
Thank you, Judge. Good afternoon, Your Honor. James M. Catterson, Pillsbury, Winthrop, Shaw, Pittman, on behalf of the appellant. Very simple case, Judge, despite the well over 100 pages of briefs. The appellants bargained for a guarantee that explicitly conditioned their personal liability on the tenant quitting and surrendering the premises, and I'm quoting, in compliance with the provisions of Articles 3 and 22 of the lease, not the entire lease. Almost 150 years of precedent, as well as the conduct of the parties, require reversal in this case. At bottom, Supreme Court's holding is very simple. Supreme Court said that it was bound by this court's decision in Empire against Sharapov, said it was controlling here, that's on record 27 and 28, and the guarantee incorporated the lease in no uncertain terms. That's what Supreme Court held. One paragraph from the bench. On its face, it seems like a reasonable ruling, because if you just read this court's decision on Sharapov, on its face, it appears correct. Unfortunately, you need to go back to Supreme Court's decision on re-argument that this court affirmed to realize that the guarantee in Sharapov is fundamentally very different than the guarantee in this case. It's not set out in the landlord's brief, it's set out in our brief, of course, the reply brief, pages 8 and 9. The operative difference is the following. Liability under the guarantee is predicated on the tenant vacating and surrendering the demised premises to owner free of all subleases or licenses, and in Broome, it's missing the word clean, but we all know it's supposed to be there, condition, and here's the kicker, and as otherwise required by the lease. That's in a decretal paragraph of that guarantee in Sharapov, which led this court to conclude that the lease was incorporated in the guarantee and therefore the tenant is bound under the lease. That, of course, is not what the guarantee in this case says. The first recital, it's on R236, says, which lease is hereby incorporated into this instrument by reference? It does say that in the first recital. In the third recital, it says, the guarantor has agreed to guarantee certain of the tenant's obligations under the lease. That's also on 236 of the record. So right away, the two recitals plainly contradict each other. In one, it's everything in the lease the guarantor is responsible for. In the third recital, they only guarantee certain of the tenant's obligations, not all of the tenant's obligations. It doesn't make any difference for the following reason. The decretal, it's on 236 and 237, Article 2A. And I'll eliminate all the excess verbiage that has nothing to do with anything. And it says that the guarantor is on the hook and is not responsible under the terms of the lease accepted and otherwise in compliance with the provisions of Article 3 and 22 of the lease. In other words, if the tenant vacates the premises in compliance with Articles 3 and 22 of the lease, it's a good guy guarantee and the landlord has no liability. There is no dispute in this record that the tenant complied with Articles 3 and 22. It's important to note that Article 25 is not in the second decretal. Article 25 of the lease is what lays out all the requirements of surrender for the tenant's obligations.
Well, isn't that an issue? Was there a surrender pursuant to the lease? Was there actually, were the requirements met for an actual surrender?
Well, that may be for the tenant's liability. That may be a question of fact. But for the guarantor's liability, all the tenant had to do was comply with Articles 3 and 22 of the lease. And we know there is no definition of surrender in the guarantee. We know that. The Supreme Court filled in the definition of surrender from the lease itself. In fact, landlord's entire argument depends upon that tautology.
But I thought it was, okay, so they remain liable until the date that Virgo, the tenant, shall return the keys to the keys to the premises to landlord and shall actually quit and surrender to landlord the premises.
Yes, Judge.
So was that actually done?
Yes, Judge, absolutely. There's no dispute that and all of the emails back and forth are in the record. We referred to them in our brief. I see my red light is on. If I could just finish
Please.
that one up, Judge. There's no question that the tenant returned the keys to the landlord and quit and surrendered the premises in compliance with Articles 3 and 22 of the lease. And if I could just finish up with this.
Well, let me just ask this last question.
Yes, Judge.
Is there any, are there any issues as to whether or not there was consent by the landlord and acceptance by the landlord of the quote-unquote surrender?
Sure, Judge. The landlord now says, well, I never gave you written permission to surrender the premises, which effectively converted the guarantee. If you accept that argument, you have converted the guarantee, which is a good guy guarantee, referred to repeatedly throughout the record as a good guy guarantee, into a full recourse guarantee at the sufferance of the landlord. In other words, and I...
Just finish that, please.
All right. In other words, Judge, when the guarantors signed the guarantee, they bargained for a certain scope of liability. They would pay the rent as long as the tenant was in the premises. This court has held that that is what constitutes a good guy guarantee. Now what happens is, after we surrender the premises, comply with the articles that are listed, the landlord says, well, I'm not accepting your surrender. So what started out as a good guy guarantee, under everybody's expectations in this record, turned into a full recourse guarantee at the landlord's discretion. Thank you very much, Judge.
Thank you. Counsel, could you actually address that last point first?
Your Honor, with respect to the question of whether there was a surrender here?
Yes, and the consent issue.
Certainly, Your Honor. So the guarantee, Article 2A, and I'm sorry, may it please the Court, my name is Caitlin Bronner. I'm an attorney with the firm of Ingram Music, Gain & Carroll and Bertolotti, counsel for 122 East 42nd Street, LLC. So the Article 2A of the guarantee specifically provides and predicates the release of the guarantors on the tenant, Virgo, actually quitting and surrendering to the landlord, 122, the premises. In this case, Virgo, it's undisputed that Virgo quit the premises, but it did not surrender them. Article 25 of the lease expressly provides that in order for there to be a surrender before the end of the term by the tenant to the landlord's written consent was required. It was not obtained here, and therefore the court below properly concluded that there was no surrender here, and that Empire versus Sharapov was dispositive. With respect to this question of whether or not excuse me, just one moment. With respect to the question of sorry, Your Honor.
Well, let me just ask this question. In reference to that guarantee section where it references Articles 3 and 22 and doesn't reference Article 25, which refers to the written, signed, writing, and consent by the owner, how should we view that in terms of the word surrender that's used in the previous?
Certainly, Your Honor. So surrender is not defined anywhere within the guarantee. The reference to Articles 3 and 25, as the court below properly concluded, dealt specifically with the condition in which the premises must be vacated or, quit and surrendered. It did not deal specifically with what constituted a surrender. The only possible source for the meaning of a surrender here was the lease, and that's for two reasons. First, because in the first whereas clause of the guarantee, the lease is expressly incorporated by reference in its entirety into the guarantee. And second, even if there had not been this express incorporation, the lease and the guarantee were executed simultaneously.
But your adversary in their papers state that that whereas clause created an additional right.
Your Honors, they state that for the first time in their reply submission. Previously, in their opening submission, they stated only with respect to the first whereas clause that whereas clauses do not strictly form part of the agreement. And in point of fact, this court in the Shalik versus Stein case, as well as the Court of Appeals in the Ronan and Maloney cases, have repeatedly looked to whereas clauses to glean the meaning of the party's intent. Indeed, it's a bedrock principle of contract interpretation that the court must try to reconcile the meaning of terms within an agreement by reference to within the four corners of the agreement. So respectfully, the reference to surrender in Article 2A and the specific references to Articles 3 and 22 of the lease, it did not need to reference Article 25 of the lease in order for that provision to be incorporated, as the Supreme Court properly concluded that it was. With respect, and I just wanted to quickly state with respect to the Four Corners Doctrine, what guarantors are attempting to do here is to read two provisions out of this guarantee. They're trying to excise the first whereas clause, and they're also trying to excise this distinct requirement of not just quitting the premises, but also surrendering them. They're trying to conflate these two provisions, and that, of course, violates settled principles of contract interpretation, including the Court of Appeals decision in the Vermont Teddy Bear case, which specifically states that a court cannot excise provisions of a contract and thereby create a new agreement for the parties. Additionally, the guarantors are arguing, in order to justify their own interpretation of the word surrender, which plainly is a surrender here, as stated in Article 2A, by the tenant, Virgo. Virgo is the entity that was required to surrender here. It could not possibly surrender under the guarantee, and the guarantee cannot rewrite the lease in this regard because Virgo is not a party to the guarantee. It was only a party to the lease, and that's the only instrument pursuant to which it could surrender. So the guarantors say we should instead look at dictionary definitions, we should look at common usage concerning the meaning of a surrender. But of course, that would violate the WWW case, and it would specifically begin an analysis, that's WWW versus Giancontieri, and it would begin the analysis with a resort to extrinsic evidence. I see my time is up, Your Honors, and unless there are any further questions, I will respectfully rest on my brief.
Thank you very much.
Thank you.
Thank you, Judge. The entire argument depends upon one thing. One thing, the first recital. We know for 150 years on cases my adversary has relied on, 150 years, that recitals do not create an independent obligation. There is no dispute. The Court of Appeals from Burr all the way to this court in Grand Manor has held the following. Recitals in a contract are not strictly any part of the contract. To accept my adversary's argument that the entire lease is incorporated into this requires you to do two things. Violate the Burr rule that has been unbroken for the last 150 years, but also ignore the third recital. So, you know, we said in the brief, the landlord can't have its cake and eat it too. They can't urge you to say that the first recital is part of the lease in contravention of all of that precedent, and at the same time ignore the third recital that says my client only guaranteed certain of the tenant's obligations. We're not excising anything out of the contract. The guarantee says what it says. The only part that's operative in terms of contract interpretation are the decretals. Case law is clear on that. Let me add to that. Surrender. It's not defined. We all agree on that. It's also not capitalized. And the first decretal says all capitalized terms used in the guarantee shall have the same meanings as contained in the lease. The landlord knew exactly what to do when the landlord wanted to write it in. They didn't write it in here. This violates contra proferendum. We drafted none of this, nor did they claim we did. It should be construed against the drafter, narrowly construed, particularly with regard to private guarantors. Expressio unius. I know, Catholic school Latin. What can I say? Expression of one thing is the exclusion of the other. expression of one thing is the exclusion of the other. The landlord wrote in, we didn't write this, the landlord wrote in compliance with the provisions of Article 3 and 22 of the lease. The landlord did not write in, also including Article 25. More importantly, I direct the court's attention to a Supreme Court case, Duval 37 Associates, long case involving good guy guarantee. The court made the cogent observation. Plaintiff's reading of the guarantee would render nearly the entire guarantee as meaningless, would render the vast majority of it superfluous. Landlord could have insisted on a guarantee that simply said the guarantor is liable for all the tenant's obligations. Could have said that. That's not what is written here, and I would be, if I could just finish the sentence, Judge, I would be remiss if I did not point out that every single guarantee case cited by the landlord, every single one of them, from Sharapov to True Legacy Partners, 274 Madison, 50 East 42nd, and Prince Street, all say exactly the same thing in the guarantee. In haec verba, and as otherwise required by the lease. Every single one of them says that. This guarantee does not say that. It was bargained for, and I urge the court to uphold the benefit of the guarantor's bargain. Thank you very much for letting me run over time, Judge.
Thank you. Thank you both. We're back to the beginning of the calendar. People versus Stephen Baylor.
Good afternoon, Your Honors. David Clem for Appellant Stephen Baylor. Stephen was promised YO in his earlier case. We know that because you could just look at the record for the promise. The court agreed with counsel when he said, Stephen, quote, will receive YO. The hearing court below's finding is equally conclusive. The hearing court below said the promise was he would be adjudicated a YO.
I thought that was assuming he abided by the other conditions of the plea.
That wasn't ever stated as a condition. It was a promise of YO. There would be different sentencing ranges if he abided by all the conditions, but he would be sentenced to the maximum possible term for a YO if he didn't, and that was 1 1/3 to 4. But we don't even have to resolve that question because my friend's position on appeal is waived, it's unpreserved, and it's not jurisdictionally before this court because we have a finding of fact by the hearing court below that ruled in appellant's favor. So we have a promise of a YO, and that has to be honored, or there had to be an opportunity.
You don't think there's any ambiguity in that premise?
There was no ambiguity in that promise. The court agreed with counsel's statement.
He gets it even if he doesn't live up to the probation.
Yes, and the court referenced then later in that plea that the promise was put on the record by defense counsel. As I said, regardless of that, the hearing court below said the promise was he would be adjudicated a youthful offender. That's beyond this court's review at this point.
That was an unconditional promise.
It was an
Unconditional promise from
It was an unconditional promise. The sentence within the YO range would vary depending on how Stephen performed under it. Given that promise.
That's not what it says. It says you'll be placed on a period of interim probation for 6 months. In that 6-month period of time, you have to prove yourself worthy to this court. An extended period of probation thereafter. Should you, during the interim probationary period, not comply with the terms in the eyes of the department, probation department or this court, you'll receive a sentence of 1 1/3 to 4 years in jail. The understanding is that you will also receive youthful offender treatment.
Yes.
But that doesn't, I mean, it doesn't really say that you will receive YO regardless of whether you comply with the terms of the plea in the eyes of probation and or this court.
The understanding is that he will also receive youthful offender treatment. The court says, okay. But as I've said a couple of times, that's not before this court.
You say under La Fontaine that's not within our review at this point, and let's grant you that for the moment. But anyhow, when he sentences a predicate violent felon in 2017, he doesn't challenge the constitutionality of the prior convictions. So didn't he waive his objection, the objections that you are now raising?
He did challenge it, but on different grounds. And counsel was ineffective in not raising it.
I'm sorry, he did, you're stating he did challenge it?
He did challenge his adjudication. He did not challenge it on the grounds that are before this court.
On what grounds did he challenge it on constitutional grounds?
I forget what the grounds were. He did say it was a constitutional grounds, although the words he then used, I'm not sure, made out a constitutional ground. But it was not the ground that is before the court. Counsel was ineffective in not raising the correct argument in that. And under Juergens,
We don't really know that, do we? Because maybe he didn't challenge anything because at that time he was getting a really good deal.
well, we do know that because he did challenge it. He raised a challenge to the predicate adjudication. He wanted to get the predicate adjudication.
I'm sorry, when did he do
thrown out.
this? When did he, I'm confused. When did he raise the challenge to the predicate adjudication? Because when he took the plea, when he took the plea, he's asked whether he, in terms of challenging his 2010 predicate gun conviction, he's asked whether or not he has any challenge, whether he wished to challenge the constitutionality of that prior conviction, and he stated no.
Yes, that's correct. But
So you just stated
earlier,
that he did challenge it.
well, in November 2016, during the pendency of the case, his attorney filed a written motion challenging the predicate conviction on the grounds that it was, quote, jurisdictionally defective and unconstitutionally obtained. That's in the record on appeal with a motion dated November 14th, 2016.
But when he's allocated on the predicate felony statement, he is asked whether he challenges the constitutionality of that conviction, and he states no.
No, his challenge had been previously rejected by that time.
Okay, you have time on rebuttal.
Good afternoon, Your Honors. Michael Tarbutton for the people. Addressing the waiver issue first, Your Honors, the defendant did waive this unless he can establish an effective assistance, and he can't under the Turner standard, which is what governs this, because this is a claim of ineffective assistance purportedly because the defendant, the counsel didn't raise one particular claim. So Turner controls. Under that standard, he has to show that this unraised challenge would have been both clear-cut and dispositive. It's certainly not dispositive here because the defendant had that second prior felony conviction that he could have been adjudicated predicate felony offender on, even if he'd raised this claim and succeeded on that. And the difference between that second conviction, which was nonviolent, and this, which was violent, wouldn't have affected the plea bargaining leverage of the party. So this would not have been dispositive. So even if counsel had overlooked this, even if this wasn't a strategic issue, and actually there are things the record suggests it may have been, it is not dispositive, and therefore the counsel wasn't ineffective. You can tell that if you look at the sentencing ranges. The defendant with this, with the violent prior, is a second felony drug offender with a prior violent conviction. The top of the sentencing range of his exposure in the first count was 15 years. The nonviolent, it would have been 12 years. But counsel here, the counsel who is allegedly ineffective, negotiated a sentence promise of 3 years. This is so far below the top of either sentencing range that it's plain that it wouldn't have mattered whether he was adjudicated a predicate based on the violent or the nonviolent. It wouldn't have changed the plea bargaining leverage of the parties, and therefore was not dispositive to the case.
So this is because he pled guilty to the criminal possession of a controlled substance in the 5th degree?
Yes, Your Honor.
And he was adjudicated a prior violent felony offender, and then he receives 3 years.
Actually, a second violent felony
Second
drug
violent
offender,
felony
right,
offender.
right.
And he receives 3 years.
3 years, right.
And the maximum would have been 12?
On the top count, on the third-degree position, it would have been 12 for the nonviolent and 15 for the violent.
And he's completed his sentence, is that correct?
I believe that's right. Yes, Your Honor, it is. Also, Your Honors, you can tell that this issue wouldn't have been dispositive because the defendant himself didn't care. During the plea allocution, the court actually misspoke and told him he'd be adjudicated a second felony drug offender with a nonviolent conviction. So after they adjudicate him based on the violent, the court corrects itself and said, I misspoke. You're actually going to be adjudicated a violent rather than a nonviolent. It told him the consequence of that. The only consequence would have been that if defendant violated this plea bargain, that he would have been exposed to a slightly higher maximum sentence than he would if he were a nonviolent predicate. And the court asked him, knowing that, do you want to go forward anyhow? And the defendant, of course, said yes, because the defendant wanted the 3-year sentence promise. He didn't care about the predicate status. So this was not dispositive. So under Turner, defense counsel, even had he overlooked this, could not have been ineffective for not raising this claim. Further, Your Honors, the claim wasn't clear-cut. The hearing court here correctly found that under the case law at the time of the Second Department, that in that predicate, that prior violent felony the defendant pled to, even had he been offered a YO in the event that he messed up and the court was sending him to state prison, even if he rewarded him with a YO, at the time, under the case law of the Second Department at the time, the court was not obliged to sua sponte offer the defendant his plea back. He had to give it to the defendant if he asked for it, but he wasn't required to offer that. So the court was correct. But more importantly, for the waiver issue, this is certainly not a clear-cut issue. One of the arguments the defense makes in the reply brief is that, well, the Second Department, if that was the law, they were wrong because the Court of Appeals plainly said you're obliged to offer the plea back sua sponte. If that's true, the Second Department misinterpreted the Court of Appeals case law, and the claim is not clear-cut. So defense counsel was not ineffective. And underlying all this, Your Honors, is the fact that the defendant was not promised a YO in the event that he violated the terms of his plea bargain and was sent to state prison. That's an improbable notion to begin with, and it certainly didn't happen here. What happened is defense counsel went on the record, said we have a disposition. Defense counsel sort of inarticulately said that the promise is 5 years, and in the event the defendant violates the plea bargain, state prison, and also he gets YO. The court gave a placeholder. The court said, okay. When the court told the defendant the terms of the plea bargain, he didn't promise him YO, didn't mention YO at all. And later on, when he referred to what defense counsel said, he did not say what counsel said on the record. He said what counsel advised you, which is off the record because counsel went on the record saying we have a disposition.
And then after he violated the conditions of the plea and was now before the court for sentencing, you argue that obviously there was some discrepancy because the court asked the parties to approach when something was stated about the YO status.
Right. What happened is defense counsel went on the record and said that the promise for the alternate sentence was YO as well, and the judge said, maybe I misread something, step up. Then they have an off-the-record conference, they go back on the record, and the judge says, based on our conversation off the record, which was plainly about whether YO was part of the alternate promise, do you have anything to add? And counsel said no. So he advisedly withdrew that claim that the defendant had been promised YO, so he wasn't offered YO.
Thank you.
Thank you, Your Honors.
It's certainly not improbable that a 14-year-old would be promised youthful offender treatment regardless.
No, and that's the whole purpose of YO, is that so a 14-year-old, 15-year-old, et cetera, would certainly be promised YO, assuming they abide by the conditions of the plea, right?
But that was never stated. The promise to you, the court said, is what defense counsel has told you. And defense counsel put that promise on the record.
I totally agree with you that it was perhaps it was inartfully stated, but again, it was based upon what counsel told him. What do we do about the fact now, again, that the defendant was a predicate in terms of the later plea?
Well, that goes to my friend's point as to whether or not it's dispositive, which of course it is dispositive. It's dispositive of Stephen's predicate status. It's dispositive of the issue about whether or not he's a predicate violent or a predicate nonviolent. and he should have been sentenced as a predicate nonviolent. The issue is also clear-cut. The Court of Appeals in Torres in 1978, prior to the sentencing provision, in a case that's on all fours with this one, stated, quote, "The failure to afford defendant the opportunity to withdraw a plea when not given the promised YO mandates reversal." That renders the predicate, the prior conviction, unconstitutional here.
Thank you so much. Thank you both. Burdell versus Federal National is submitted. Rivera v. Shea.
Good afternoon, Your Honors. My name is Philip Seelig, and I'm representing Police Officer Carmine Rivera. I'd like to present two items for the court to consider. I know that you've reviewed the record. You've stated that at the beginning when you did the calendar call. So I don't want to get into the minutiae of the two sides, but rather try to give you an overview of what I believe the two salient points are for you to consider in your deliberations. The first one has to do with whether or not a police officer injured while during the time of portal-to-portal pay, as expressed as a city service, as in city service as expressed in the Administrative Code 13252.
So it's my understanding that the portal-to-portal pay was a was pursuant to a collective bargaining agreement with the union, so that these officers would be compensated for the portal-to-portal, right?
Yes, and to explain it further, typically a police officer is assigned to a certain precinct.
Right,
or
so she was
detail.
assigned apparently to a precinct in Brooklyn. She lived in Lower Manhattan. She was now reassigned to 1 PP, 1 Police Plaza. She's on her way to 1 Police Plaza. She's in uniform. The gust of wind blows a fence into her, and she falls and she's injured. So now she's going to be paid for the portal-to-portal, and the issue is whether or not she's in city service. So again, the portal-to-portal is compensation based upon the collective bargaining agreement. Where is it that states that that would also constitute in city service?
Okay, so there's
And this is
nothing that
just to
says
add
in
to-
city.
Just to add to what Judge, and this happened an hour before she went on duty.
No, that's not how I would characterize it. It's
It wasn't an hour?
before, if I may be respectful of the question to give an answer. When you said before she was on duty, it is our view that she was on duty at the commencement of the portal-to-portal time.
Was she supposed to start? Let me
permit me to
interrupt.
please give
No, no. That's not how it works. See, we ask the questions and you're quiet, and then you respond to our questions.
But you
Okay?
cut me
No,
off.
see, you're not paying attention.
I am.
Okay, so we're going to try this again. Justice Friedman is going to ask you a question, and then you are going to respond to the question asked by Justice Friedman. We'll try it. Go ahead,
Was she
Justice
supposed to
Friedman.
go on at 7:05 a.m.?
I'm sorry, I didn't hear
Was she
you.
supposed to start at 7:05 a.m.?
The tour of duty where she stands roll call starts at that time.
And at what hour did this happen? Because my reading of the
hour
minute
previous.
shows that it happened at 6:05 a.m.
An hour previous to that.
Okay.
So, as you know from other cases before you, that sometimes officers work overtime. They work overtime before the scheduled tour of duty, and they work overtime at the end of a tour of duty. This payment of portal-to-portal is overtime pay. And what happened in the history was that when people were assigned to other jurisdictions other than their normal assigned tour, they put in for overtime pay based on their travel time. And this created administrative difficulties for the police department. So in negotiating, it was resolved that rather than do it on each individual case, there would be a payment of a certain amount of overtime if they had to go to a different assignment within the borough, and a greater amount of overtime if they had to go to a borough outside of their normally assigned tour.
counsel-
It is still overtime.
Counsel, 1 second. Justice Gonzalez has a question now.
Yes.
So, counsel, for me, the question here was whether this was a stipend or whether this was overtime pay. And I'm looking at the CBA in the record at 614, Article 10 of the collective bargaining agreement is entitled Overtime Travel Guarantee, and this enunciates the portal-to-portal compensation, right? But what's interesting to me is the part that says at Section 3, the overtime accrued pursuant to this article for any one day shall be taken by the employee at the employee's sole option, either all in cash or all in compensatory time off. So that's Section 3, where it talks about the overtime accrued pursuant to this article. Is it your position that it's referring to the portal-to-portal traveling from one place to the other as overtime, or is it referring to something else?
Well, overtime pay for police officers is always paid in either cash or compensatory time balances at the option of the employee. That's true of all overtime.
But my question is not that. The question is the portal-to-portal payment, the travel compensation. It's time, right? It's an hour and 15 minutes in her case. So is that considered overtime accrued, or is it merely a stipend for traveling?
Well, there's no such language as stipend in the contract. That is a manifestation of the Board of Trustees, city trustees, who called it a stipend. But as you know, it's not the language of whether it's a stipend or not. It's whether or not she's doing something for the benefit of the police department when she's ordered to report to another command. She is traveling pursuant to the contract and pursuant to those orders. She is not doing something that's a lark of her own. It's not for her personal benefit. It's for the benefit of the agency. And I would submit to you—
You have time on rebuttal. Thank you.
Good afternoon, Your Honors, and may it please the Court.
So, Counsel, we could follow up on that. In terms of the history, in looking over the decision by the Board of Trustees, they go through the history, the purpose of portal-to-portal, and they do say that, that it was treated as a stipend or allowance for compensation for the inconvenience of traveling to a temporary post, as opposed to compensation for overtime duty. So where did they get that from?
Yes, Your Honor. Well, very briefly, Ben Pollack for the respondents. So there can be no real doubt here that portal-to-portal time is a travel allowance. And
no, but counsel, the question is, where did this definition come? Where did this come from? In the sense that if you look at the transcript, the members of the board, of the pension board for the police, they talked about, well, I talked to this one, and I talked to that one, and I talked to the deputy of this. Who's that deputy? I don't know him. Oh, that deputy is so. I never heard of such a discussion.
So what is the basis for the determination or the statement that portal-to-portal is a stipend and is not compensation for overtime?
So Your Honor's questions go right to the heart of this case, and there are three places where we can look for it. The first place, the earliest indication of any history of portal-to-portal time in the record, is the arbitration from the early 1970s by arbitrator Dash. Now, in that document, portal-to-portal time is referred to as an allowance, I believe 49 times. And I want to speak to the substance of that in just a moment, but it's also worth noting very briefly that it's also referred to explicitly as an allowance in the collective bargaining agreement that governs it. Now, to get to the heart of why it's an allowance and not payment for service, we really need to look at a few things here.
Excuse me, counsel, where does it say allowance? I'm looking at Article 20. What paragraph is that?
I apologize, Your Honor, I don't have it in front of me. I believe it's one page.
But I don't see it.
We quote it in our brief. And if Your Honor would like, I would be happy to submit a
Just
letter
continue with
to
what
the
you were
court.
saying, counsel, please.
But I can assure you on that one page, it's described as an allowance. But the real reason why it's more akin to a stipend than to payment for work is that it is no relation to the actual amount of time spent in transit. And in fact, it's a negotiated benefit that at this point is really severed from its original purpose. Now, I'm sure it seems that Your Honors have read the record very closely, and you will have noticed, and we flagged in our brief, that arbitrator Dash envisioned this as compensation for loss of time and inconvenience under a very specific scenario. In that
Again,
scenario,
counsel, it's great that what arbitrator Dash envisioned, but what is this vision based upon? That's what we're trying to get at. What is it based upon? Is it just based upon practice, procedure and practice up until that date? What is there something in writing? Is there something that that shows us exactly the basis for this vision by arbitrator Dash?
yes, Your Honor, arbitrator Dash explains that his vision was based on common sense. If an officer has to travel all the way out to their home precinct, then travel to a to change into their uniform to get their equipment, and then travel to a special assignment, and then at the end of an 8-hour shift, travel back to their home precinct, and then travel to their home.
And so how is the calculation made? It was discussed previously. She apparently, this occurred at, I think, 6:05. She was supposed to report at 7:05. So would she put in for this portal for an hour or whatever her travel time was going to be, or was it a fixed amount?
It's a fixed amount, Your Honor. So because her home precinct was in a different borough from her special assignment, Brooklyn and Manhattan respectively, she was entitled to an hour and 15 minutes, starting an hour and 15 minutes before 7:05, before her tour of duty began. And she was not in duty, by the way. I mean, her tour of duty was
That's
clearly
another
set to
issue.
begin
So it's a
later.
fixed amount. So that goes to your argument, or at least that goes to the Board of Trustees' determination that it's not compensation for overtime because we're talking about travel time.
Precisely, Your Honor. And in this case, in fact, we know that her travel to the special assignment was only half a mile. In fact, it was far more convenient.
Okay, your time is almost up. So one last question by myself. There is a 2006 decision wherein ADR benefits were granted to another officer purportedly in a similar situation. Apparently, this was not relied upon by the Board of Trustees in this particular case. But there's nothing in the record that I saw wherein it spoke to why that 2006 determination was not being followed, how it's different, if any, from this particular case, and why, therefore, you strayed from the precedent.
I see my time's up, and may I answer?
And you can
Your
answer the
Honor's-
question.
Thank you. So to speak to your question, Justice Weber, the 2006 decision in this record is 6 sentences that reveals nothing about the facts except that it involved a detective on a motorcycle traveling back to some unidentified place on portal-to-portal time. What we don't know is what's really important here. We don't know where he was traveling to. Was he recalled to duty? Was he detouring to take police action? We don't know any of those facts. And so it's well settled that for an agency's decision to be arbitrary and capricious, the agency must reach a different result on the same facts without explanation.
But also, in that regard, when you turn to page 851 of the record, and this is Chris McGrath who's arguing on behalf of the police officer, he says, now while I say that it's not controlling, it shouldn't be ignored. It shouldn't be cast aside without considering it. It's very important evidence. And then again, at page 852, he says, no, not necessarily controlling, another piece of evidence. He doesn't say it's a controlling precedent, and he concedes that it's not controlling, and at the end of the discussion of this matter, the board takes the position, the person speaking on behalf of the board takes the position, does she not, that it was wrong, and it was wrong, we're not continuing to make the mistake.
Yes, may I speak to your question, Justice Friedman?
Please.
Yeah, that's absolutely right, Your Honor. So The trustees deliberated over 7 months and adjourned multiple times, and several times to try to figure out what was going on in this 2006 decision, because the union side trustees really pressed very hard for its significance. And so the city side trustees—
But Commissioner Zimberg simply said in reference to the 2006 decision, which could appear to be controlling here, it's not relevant. Why not? It's not there in the record. It's not there. What we have is a whole bunch of, I talked to this one, I talked to that one, this one told me this, and this one told me that.
Yes, Your Honor. So after that statement, which was quoted several times in my friend's brief, the trustees actually adjourned again to try to figure out what was going on. And all that we know, from the best that I could discern from this record, is that there's just no information about why they reached this decision in 2006.
Isn't that problematic as far as why they would cast it aside at this point?
Respectfully, Your Honor, I think it cuts the other way, because they looked at this decision and they tried to figure out what the basis of it was. Finding no basis, they conducted their own research, and again, over 7 months, they looked at the history of portal-to-portal time, and they looked at how it's considered in the city's timekeeping system, which is not as hours worked. So if you work a full 40-hour work week, and then you have 4 hours of portal-to-portal time, I apologize. If you work a 16-hour work week, if you work 16 hours, then you have 4 hours of portal-to-portal, you are not then entitled to overtime for your next 4 hours of work.
I think in following up on that discussion at the board, I think this is also McGrath who says this, who said, I believe the issue is whether the detective was on duty during the portal-to-portal period, and we have done our research into other instances and agreed that he was on duty on that time and therefore will be approving the upgrade, referring to other other cases where ADR was given. And then he says, he previously says, so it's important, I think, from a precedent point of view, is it controlling? Do you put aside your rationality? Do you put aside your reason and logic in determining these cases? Of course not. But you got to take it into account. So the argument made by McGrath is not that this is controlling, it's it's a piece of evidence to be considered.
Yes, Your Honor, and I mean, I see that I'm way over time here. May I briefly speak?
I think that was a friendly question. Thank you very much.
Okay, thank you. We would ask this court to affirm.
I'd like to answer that question posed just to opposing counsel a moment ago in regard to the 2006 precedent. And I think that the most telling way of evaluating that is under the Lantry v. State case, which is a Court of Appeals case, which says that an administrative agency that neither adheres to its own prior precedent nor indicates its reason for reaching a different result.
But Counselor, your own advocate at the hearing doesn't call it a precedent. He calls it some evidence.
Well, it's not, it's the advocate for the PBA and a trustee, but we can, as a representative of the police officer on this appellate brief, disagree with that assertion even by the PBA counsel. I think the greater evidence for how you should look at it is what the Court of Appeals has said about this.
So you mean even though he only called it some evidence, you are now calling it a precedent which is binding upon this court?
Well, according to Lantry, it is, unless you can demonstrate a deviation and distinguish what happened here from the prior precedent.
Wouldn't you have to argue below that it's a precedent?
We put that in our earlier argument below, and the Judge Frank ruled against us.
I meant not below, but before the board.
That we had put in an argument that there was, in fact, Trustee Sparks, Kenny Sparks from the DEA, mentioned about this prior case. And so the case is there. It's there for the board. The board knew that there was a precedent, whether they called it or not, a precedent or not. They merely knew about it, and they knew how it was treated in the past. And to deviate is the epitome of capricious and arbitrary unless there's a ample reason for a deviation. Lastly, this member was paid. I don't know any instance where the city of New York is so generous as to pay an employee for doing something and say that it's not providing a service to the city. She was in city service. She was doing the mission of the department in going to another command based on the order of her commanding officer, and she was paid for it. That is in city service. They don't give away money for nothing.
Thank you.
Thank you.
Thank you both. Davis versus Brown.
May it please the court, my name is Marjorie Berman, and I represent Mary Davis, the appellant and a former dean of the Fashion Institute of Technology. We are here today asking the court to reverse the decision of the lower court that granted FIT's motion to dismiss. On February 20th, 2020, Mary Davis was enjoying a stellar reputation as Dean of the Graduate School of the Fashion Institute of Technology, and as a scholar, an author, a musicologist, and an academician. The next day, that reputation, which she had spent more than 30 years developing, was instantaneously shattered by a defamatory press release that FIT issued to the community. That press release, which...
So, counsel, how does this letter constitute defamation by implication? What in the letter would constitute defamation by implication?
If you look at the letter in its totality, and you look at the facts that are alleged, that those responsible for supervising the show provided accessories to the fashion designer, and that those persons, in providing those accessories, failed to recognize the racist references in...
Well, the letter does not say that your client provided the styling and accessorizing used in the show. It states that the young, I guess he's an alumni, Huang, was the individual who actually did the styling and accessorizing, but it doesn't say that your client supplied these items.
No,
correct?
That is correct, but it is a very small leap from the statement that those responsible for the show provided the accessories, saying that FIT is demanding accountability, and then concluding with the line, as a result, we are placing Mary Davis on leave.
And we're commissioning an independent investigation.
But they're not commissioning an independent investigation to determine who provided the accessories. They know.
As a result, we are announcing the placement of your client on suspension, right? That's the last paragraph.
That is correct.
Separate paragraph, it's the last paragraph, where they talk about what occurred in terms of the styling and accessorizing, et cetera. It does not mention your client. It states that those in charge of and responsible for overseeing failed to recognize the racist references.
Your Honor, that is correct, and that is exactly why there is defamation by implication. The standard before the court is whether or not reading this press release in full context, a reasonable person could believe, come to the conclusion.
It's plaintiff's position, is it not, that she had nothing to do with this, and in fact, the rules precluded her from being involved in it.
100%.
And then when this press release is issued, announcing her suspension or her firing, the effect of that is to mislead people into believing that she had something to do with this personally.
Well, That is certainly how we read the press release.
I mean, that's the implication, is it not?
Yes, it is. And that is exactly how the press read the press release. Nobody thought the press release was about commencing an investigation. The media, when they reported this, and they reported it worldwide, blamed Mary Davis for the fiasco at the show. And that is the defamation.
But after the show took place, the president of FIT praised the show, did she not?
She praised it right after the show. She praised it that evening. She praised it in emails.
Until there was negative publicity, until there was a negative reaction.
That is correct. In fact, if you look at the dates, the show was on the 7th. Everything was fine until the 15th when the Post article came out. Even on the day of the Post article, the administration was still lauding the show.
And there was a video produced, right?
There was a promotional video.
From the show, lauding the show.
The promotional video contained excerpts that included these supposedly offensive accessories, because at that point, nobody had noted that they were. Nobody had come to the conclusion that perhaps they were offensive.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Ricky Rohr. I'm from Wilson-Elser, and I represent the respondents, Dr. Brown and FIT. And if I could pick up with the questions where you all left off, there are very distinct reasons why this case does not satisfy the stepping-off requirements for defamation by implication that this court set in 2014. The scope of the investigation, and again, the most important thing is the context, the exact words, and whether they are susceptible to being proven true or false. Here, the context of this letter clearly said, we understand our community is upset, we are committed to investigating this, let's put everything on pause while we commission an outside investigation.
I don't know that you can really go in that direction, counsel. I'm looking at the letter, and I'm going to just jump from one paragraph to the other. It also appears, based upon information available, that the styling and accessorizing used in the show were provided to the student, who would now be alumnus, rather than chosen at his discretion. To us, this indicates that those in charge of and responsible for overseeing the show failed to recognize or anticipate the racist references and cultural insensitivities that were obvious to almost everybody else. I'm jumping. With this in mind, as the investigation unfolds, we would like the community to hold us, rather than the student, accountable. As a result, we are announcing today that the dean, who is the plaintiff in this case, and the chair of the fashion design department have been placed on administrative leave pending the conclusion and outcome of the investigation. It is so linear. I don't follow your reasoning.
And I would just refer the court to the very first paragraph, which defines what the scope of the investigation is. And I give plaintiff's counsel credit for trying to say this is just about the accessories. If Ms. Davis did not choose the accessories, there is no reasonable basis for her to be included in the investigation of what led up.
Counsel, so you agree that there was defamation by implication from what you're saying?
Not at all, Your Honor. I'm saying just the opposite. First and foremost, the investigation that was being commenced, unlike defamation by implication articles, there are cases, this is not a case where a statement was made that was capable of being proven true or false that was defamatory. what was said was an investigation is going to start. We are going to look into what led up to and what followed the fashion show and the fashion show.
But the letter says, with this in mind, as the investigation unfolds, we would ask the community to hold us accountable. As a result, we are announcing these two people were suspended.
They were not suspended. They were placed on administrative leave.
I'm sorry, what's the difference?
Well, suspended, I think, carries a punishment aspect. Administrative leave says there's been a debacle in the graduate school of which the appellant was the graduate school.
You don't think that the circumstances of this didn't cast, you don't think that the circumstances of this didn't cast a negative light upon the plaintiff?
I think what cast a negative light upon the plaintiff and upon FIT was that there was a student body in an uproar, a model in an uproar, and feelings of not being heard.
But how is the blame for this not being directed towards her?
It is straight on point with Stepanoff and Doe v. Syracuse. Doe v. Syracuse is so on point in terms of saying an investigation is ongoing. We are going to look into it. We feel that what occurred on the video was racist and anti-Semitic and violent.
But what you say makes it seem like she had something to do with what happened. And the facts show, which the defendants had to have known, that she wasn't even permitted to take a role in this.
She wasn't permitted to?
She wasn't permitted to direct what they're supposed to do.
In the four corners of her complaint, she establishes she had a direct role in overseeing what was going on in the studios. Page 58 and 59 on the record of appeal in paragraphs.
But she could not provide any of the accessories or the styling. And that was the whole point, wasn't it, that for whatever reason, the accessories that he ordered, they were on back order or they were coming in late, they would not be ready for the show, and so therefore he had to run and get additional accessories, and that's where all the issues came from?
As this court said in Stepanoff, the fact that the plaintiffs in Stepanoff weren't in the corporation when the alleged funds came in from the Russian government, but they had a role in the business of the Global Enterprise, Inc., or whatever it was called.
But her role, I think the point is that her role was limited, and the letter makes it seem that her role was far more expansive than it actually was. And the issue also is, you were kind of parsing out paragraphs. Should we not read the letter in its entirety?
If I may, Your Honor, I agree completely, but the letter in the entirety is she was the dean of the graduate school. By her own memo and her complaint, she says, the buck stops here. Come to me. I will be in the studio.
Right, but again, she's the dean, and it says, those in charge of and responsible for overseeing the show fail to recognize or anticipate the racist references and cultural insensitivities. So would that not lead a reasonable reader to conclude that she, the dean, who was responsible for overseeing the show, was racially insensitive?
And going back, Your Honor, those terms for decades have been held by this court and the Court of Appeals not to be actionable as defamation per se or defamation by implication. Saying someone made bad judgment and their bad judgment, and that she was not, what it was saying that there was bad judgment here in not recognizing.
So I'm sorry, you're saying that these cases state that a failure to recognize something that is racially insensitive or is racist is not defamation?
What I am saying, and what I believe the Court of Appeals and this court has said, is that allegations someone made a bad judgment, someone did not anticipate an outcome, or even words like they are a racist or this was a racist writing have continually been held not to be actionable as statements of fact. They are protected opinions. They are not capable of being proved true or false. They do not have a precise meaning. And particularly in the context of saying we are starting an investigation of what went before, after, and at the fashion show, the plaintiff, Dean Davis, cannot say, like Claude Rains in Casablanca, I'm surprised there's gambling going on. This was a debacle.
And then collect his winnings. Thank you very much. Appreciate it.
We watch the same movies, Your Honor.
I love it.
Thank you.
Counsel, do you agree with the last statement made by your adversary?
This case is not about whether or not Mary Davis was called a racist. That is not what it is about. It is about whether she was accused of engaging in conduct, of failing to carry out duties related to the fashion show, related to the accessories. Do not get fooled by the racist. It says that those in charge of and responsible for the show failed to recognize or anticipate the racist references that everybody else was aware of.
Almost everyone. Almost
everybody else was aware of. The issue, though, is about being accused of conduct that she did not engage in, and is very clear from the complaint that she had no opportunity to see their accessories, she didn't see the accessories, she had no opportunity to perceive or not to perceive, to recognize or not to recognize. And this statement taken as a whole leads to the inescapable conclusion that she had such opportunity and that she really messed up on that opportunity. It is about the conduct. And, I urge your honors to look at Doe v. Syracuse. The defendants rely on it, but it is not applicable. That was not a case about conduct. That was a case about an opinion about somebody's conduct. This case is about whether or not she did or didn't engage in this supervision of the show and the ability to see the accessories. And that is a fact that can be proved, true or false. Thank you, Your Honor.
Thank you.
Any more questions?
Thank you very much. Federal Insurance versus Lester Schwab.
You gotta be very popular. What a big show you have.
Good afternoon, Your Honors. Michael Furman on behalf of the appellant Lester Schwab. Your Honors, in this case, the plaintiff, Chubb, truly has no one to blame but themselves if they truly believe that the underlying case, the Wilgerot case, which settled for $4 million, settled for more than it should have. It's undisputed here, in this case, Lester Schwab was retained by the primary insurer. The primary insurer had policy limit of $1 million. This is a very serious case with very serious injuries. Chubb had the excess coverage, $25 million over $1 million. And Chubb knew that this was a very serious case. They retained their own monitoring counsel, Amity Demers, right from the start. So they knew right from the start that this was a serious case to monitor. Throughout the life of this case, which started in 2013, it wound up being settled in September of 2017. Chubb was aware that there were numerous opportunities to settle the case for less than $4 million.
But as to the legal malpractice claims, the allegations are that your client failed to properly investigate the facts. There was a conflict of interest, failed to secure complete medical records, failed to serve 3101D notices, directed the pain management doctor not to opine as to the cause of the plaintiffs, the injured parties, pain, and then, of course, we have those conflict issues, no cross-claim to the city, no opposition to the city's motion for summary judgment, but also, importantly, no investigation of the accident site until 2 years post-accident. So how do you get around that?
Well, I'm so glad you asked that question, because in the record, and forgive me if I don't know the page citation, but there's a very long first report by Lester Schwab that was prepared in 3 months after they were retained, where they did investigate. In fact, a lawyer for Lester Schwab prepared a report with photographs of the accident site demonstrating that the defective condition, was on the property of their client, Manchurian. So, in other words, that allegation is rebutted and not true, simply not true, because Lester Schwab did, in fact, conduct a site investigation, did, in fact, take pictures of the location.
Am I right about that report? While it is submitted in the record as part of Schiaffer's affirmation, I think, but you don't really come to seem to rely on it until your reply brief.
Oh, we do. We rely on heavily in the reply brief because it's...
Yeah, but isn't that the problem? You needed to rely on it in your main brief.
Well, because the primary focus in the main brief, Justice Friedman, was on proximate causation, because it's just standard law in New York that in order to prove a case against a law firm, you need to have proximate cause, but for causation, you can't rely on speculation. Here, in this case, the damages, there's no dispute over the damages. They were serious injuries, 7 surgeries, 2 more contemplated, large economic damages. The sustainable verdicts in this court, it referenced at page 21 of our main brief, demonstrate that they were well over $4 million. If anything, Chubb got a bargain. They should have settled earlier, again, when there were clear opportunities, undisputed opportunities to settle for less than $4 million. They refused to engage in that process. And then they took the chance at the very end and swooped in. But Justice Gonzalez, just to address the other points, because you raised several of them, and we addressed them all in the reply brief. The expert disclosures, for example, the allegations are simply not true. The plaintiff served their expert disclosures. There was a trial date in September of 2017. The plaintiff served his expert disclosures in August of 2017. And the records and the IMEs, which were the basis for the experts, both of the complex regional pain syndrome and also of the neurologist, those were already exchanged. It would have been maybe 2 hours of work to simply just put together a response and submit the CPLR 3101D disclosure. So that's a false allegation. It's demonstrated by the record.
Thank you. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon. Excuse me. Good afternoon, Your Honors. All right, one more time. Amanda Nelson of Cozen O'Connor for the respondents. I think Your Honor's questions hit it on the head. There is, and under the context of, this is a 3211 motion. We're just looking at the 4 corners primarily, notwithstanding what was raised principally in the reply brief. And there are 14 pages in the complaint detailing multiple acts of malpractice, and not merely saying, oh, they did this wrong, saying they did this incorrectly. They failed to have this site inspection. They failed to retain this expert, and in the weeks between when they were replaced and trial, when we did retain that expert, we discovered that his testimony would have been this accident could not have even occurred how the plaintiff claims it, the underlying plaintiff. Now, naturally, all of this comes into the whole case within a case. Ultimately, yes, we'll have to prove that. But here we are, just looking at our allegations, and the allegations are very detailed, very in-depth, and not only rely on the very documents provided by defendants, including their initial analysis that the case was worth $500,000, which several years later, after the result of all the malpractice, after having their expert after having a contempt finding issued against their expert, where they did nothing, and the entire contempt was based on the expert not providing documents in response to subpoena that the defendants had given to the expert. And not only, and I understand that in reply they make the point that, well, he wasn't actually precluded, the court did find that plaintiff was prejudiced by his failure to provide those documents. So looking down the barrel of a trial with no experts, no 3101Ds, no vocational expert at all, despite representing 2 to 3 years earlier that they should hire one, they're left with a horrible opportunity, a horrible position of having to settle on the eve of trial. And subsequent counsel did what they could. They had a few weeks. They sought the authorizations. They requested leave to send the late 3101D, requested leave to do IMEs that defendants never had done, even after multiple surgeries.
Well, they argue that you should have engaged in settlement negotiations and apparently tendered the policy.
And I think that is certainly a question for trial, but at the end of the day, we're talking about the $1 million tender, whether they would have accepted it. There's nothing saying that they would have accepted the $1 million and then our $3 million that's really at issue here would have been obviated.
But don't they claim you are unwilling to participate in meaningful negotiations?
They do, but not anything that is documentary proof that utterly refutes the statements in the complaint. And with the background of that, here you have a situation where, for example, the contempt motion that I just discussed, they didn't tell them about that for a year. We only found out about that on the mediation, which predated by, I think, 2 weeks, substituting them as counsel. So not only do we disagree that they didn't meaningfully engage, and then it's based on certainly self-serving letters, but they weren't given all of the information to.
Counsel, let me jump in. Could you explain why you think that your fraud claim is viable and why you think your negligent representation claim is viable?
Certainly, absolutely. So they argued
your adversary says that they're subsumed under legal malpractice.
Right, exactly. And then there's case law, and the case law is that if they relate entirely to the same claims, the same causes of action, naturally they would be duplicative. Here, the misrepresentation actually predated and separately postdated the representation by the whole issue that they were conflicted out. We allege that they specifically told someone, no, there's not a conflict. All they've submitted is an email from one party saying, oh, this will confirm that we told you there's a conflict. So it's separate. So there's, if I may just.
Your complaint makes reference to a letter which you chose not to submit as part of the complaint or into the record, but that the letter says, oh, yes, we have a conflict. They've conceded they have a conflict. They sent an email on April 16th to the person who's hiring them. We've got a conflict.
Mm-hmm.
So those matters that you point to in your complaint is showing that they had a conflict and didn't disclose it. There's an email which shows that they did disclose it. That's just confirming that which they've been saying.
May I respond briefly, Your Honor?
Please.
There is the email saying, confirming, oh, we told you that there's a conflict. Also within that email, there's a downplaying of that conflict, a sort of disregard that, well, we're the target anyway. And then once you get into the actual malpractice, which I think becomes separately.
You're talking about a letter to an insurance adjuster who deals with these matters all the time, who knows that the city is a defendant in the case, and they tell that adjuster, we can't do any cross-claim against the city, and that's downplaying the conflict?
I think by saying that they were the target, that as though the city was completely inconsequential, so it didn't matter whether they would do anything or whether they could assert any
And
cross-claims.
what reflects, in terms of a fraud claim, that that statement was made with deceptive intent?
In the context of deceptive intent, in that they were saying, well, it's deceptive intent in that they were specifically told, okay, there's no conflict, or there is a conflict, but we're going to get a waiver. But we didn't get a waiver, but we didn't reach out to
Their
this
failure
person.
to get a waiver may be a very good issue on the malpractice claim, but it doesn't go to fraud.
But if they were saying beforehand that they were representing that they would get, or at least attempt to get a waiver, before there became an issue of divided loyalty, I think that would still fall under the misrepresentation.
Thank you.
Great. Thank you, Your Honors.
Justice Freeman, thank you for raising that, because there's so much here to talk about. I didn't address it in my opening argument, but the non-existence of a
Does your
conflict.
failure to get a waiver reflect fraud?
Well, it doesn't. It does not. The issue with the fraud, I think it's combined with the legal malpractice as well. And just if you'll indulge me. First, there was no fraud. It was disclosed right from the outset that Lester Schwab represents the city. Also, the facts in this case, which were clear from the outset, was that the defective condition.
Actually, it was disclosed 3 times, including that report which you spoke of in
That's
your
correct.
main argument, but you don't rely on that report, which is duplicative of what's in the email anyhow, so I don't know that it matters, but I don't think you rely on that report until your reply brief on the fraud point.
Well, again,
Doesn't matter.
There's only so much you can say. There's so much here to defend ourselves because, and it's interesting. It's as if Sigmund Freud was here. My colleague mentioned that the expert was precluded. Obviously, it was not precluded. That's so not true. It's completely false. There was a contempt finding. The plaintiff had asked for a negative inference. That was denied. There were reasons why, the main reason why Lester Schwab didn't appear on behalf of Dr. April is they don't represent Dr. April. But be that as it may, again, this is legal malpractice. You've got to prove causation. It's a big nothing burger because there was nothing that precluded Dr. April from testifying. Dr. April, by definition in his IME reports, relied on the documents that my adversaries claimed were never produced. It's in the record that they were produced. Again, so I would urge you to read the reply brief because we take down all of the assertions that Justice Gonzalez, you raised, and I wish I had more time to address, but each one of them are addressed in our reply brief.
Thank you. Thank you both.
Thank you very much. I appreciate the time.
McCartan versus Shea.
Good afternoon, Your Honors. May it please the Court, my name is Tim McEnany of Goldberg and McEnany, 516-775-9400. I represent the appellant NYPD officer Stacy McCartan. The main issue in this appeal is whether the appellant's injuries were caused by an event which qualifies as an accident under the pension law, which requires the injuries sustained to have been caused by a sudden, fortuitous mischance that was unexpected, out of the ordinary, injurious in impact, and not due to the willful negligence of the injured party. The court below found that the appellant's injuries were not caused by anything approaching an accident.
So counsel,
for pension purposes.
You're quoting from, I don't know if it's pronounced Pastolovi or Pastelov, but But in that case, that was a trip and fall occasioned by a fire hose in the middle of a rescue scene that admittedly was chaotic. And the court there said that this could not be described as a misstep in the ordinary course of employment. How would you contrast that situation with what some could characterize with respect to your client was an ordinary trip and fall while she was working?
So a fire hose may be expected to be found at an accident scene where a fire has taken place. Here, this was an abandoned hallway that led to the gym for the NYPD in their basement. At the bottom of a staircase, the discarded piece of equipment, which the judge below mistakenly believed was a full sit-up bench, was actually one piece that had broken off the sit-up bench, which they describe in, respondents describe in their brief at page, in their lower court brief at page 420 as a bulky object some 18 inches tall. So the judge, in believing that this was a bench and that it was 18 inches tall, is picturing something entirely different from what the respondents have now admitted for the first time on appeal was actually just a T-bar.
Your client described it as an equipment that was a fragment only a few inches high, but then Mr. McGrath, he was a PBA representative, I believe?
PBA union attorney.
Okay, so he said that the size was like 1 to 2 feet in length, one or the other.
Yes, 1 to 2 feet in length.
That's a very big disparity as to the measure. What difference does that make in your analysis, please?
Enormous, Judge, and that's a great question. So what they described in the respondents' current papers, but never before below, is that it was not, in fact, the sit-up bench that she tripped over, which would have been much larger than what they did describe, which was a T-bar where you put your feet under it. So a bar about like this, which obviously is not standing 18 inches tall like all of the seat cushions on all the chairs in this courtroom. So what the judge was envisioning from their description of a bulky 18-inch tall object was a full exercise bench in the middle of the hallway, which would have been about 10 or 11 cubic feet if you go by those measurements. What was really in the hallway was a T-bar that you put your feet under to secure them when you're on the sit-up bench. This is much smaller. This is not something so open and obvious that only willful negligence could have caused her to fall over it. This is something that anyone could have missed. And its placement, which was just outside the doorway at the bottom of a set of stairs into a hallway where no equipment is stored, was sitting right there where she could trip over it the second she made her left-hand turn into that hallway.
So it's the metal T-bar by itself, it does not include the bench?
Does not include the bench, and this is conceded. It was just the bar, but the judge at record 12, you could see, clearly believed this was an entire huge piece of equipment that she could not have missed, which would have been about the same size as a medium-sized chest freezer.
And so were photographs provided to the judge?
Photographs of all the hallway, the equipment, everything was provided below.
So the majority said in Pastolovi that normal risks in most jobs are not unexpected. So
this is not a normal risk of the job.
That's what I'm asking you.
Right, this is not a normal risk of the job. This is completely out of the ordinary. She had no way of knowing that this recently discarded piece of broken gym equipment was in the hallway, nor should it have been in the middle of the hallway. And in fact, it was in an area so dangerous, it was right in front of a drinking fountain. So when she fell, she hit her face on the drinking fountain, cracked a rear molar, and suffered disabling injuries to her neck and to her shoulder, which no one disputes are disabling. She could not have known this piece of equipment was there. This is unjust, and we ask that you reverse this as a matter of law and grant her benefits. It's no question she's disabled. The only question was this accident versus incident issue, and it's clear. This was an accident.
Thank you.
Thank you.
Your Honors, may it please the Court, my name is Amanda Abata, and I represent the city respondents in this matter. With regards to the dimensions of the alleged piece of disabled equipment which caused Ms. McCartan's injury, it should be stated that If you could turn to page 355 on the record, you'll see a picture of an analogous piece of gym equipment where Mr. McGrath, on behalf of Ms. McCartan, circles the portion of the equipment that was left in the hallway which caused her injury. Mr. McGrath also simultaneously, during one of the 3 hearings, described the dimensions of the equipment as being 1.5 feet by 1 foot in dimension. So it's a substantial item. And all of these characterizations of a portion of this, Mr. McGrath described during the Board of Trustees hearing that the whole bench is roughly 7 to 10 feet. And he went on to describe that what was here, what caused Ms. McCartan's injury or petitioner's injury, was roughly 1.5 feet to 1 foot. That's a substantial item. And it was discussed at length during the Board of Trustees meeting with regards to, and it was circled, and more importantly, the item is substantial, especially with regards to the fact of the location in the hallway. The hallway was otherwise unoccupied. There's no issue in terms of lighting. It's a big item.
Well, I think your adversary, Mr. McGrath, he referred to it as a deserted hallway. I think that's what
He said abandoned, and
abandoned, yeah.
It's not abandoned, it's a hallway.
Because I thought it was the hallway on the way to the locker rooms. I thought she was going to her locker room.
It is. It's one. Apparently there are multiple entrances to the women's locker room and to the gym. And Ms. McCartan was walking from the first floor down to the basement, and she entered into the basement hallway. To the right is the men's locker room. To the left is the gym and the women's locker room. She made a left. She took several steps based on her own incident report, and then she encountered the object which caused her to trip. But all of this discussion about the dimensions of it's worth noting here that the dimensions came from Mr. McGrath. All of the evidence that was put before the Board of Trustees came from Ms. McCartan's representative.
And as you look at the photos, you're going from a doorway into a hallway, and there are twists and turns in that hallway. Was it possible to see it as you came down that staircase?
Your Honor, it's important to note that as the petitioner walked from the stairwell into the basement, there is a door, and there's a doorway and there's a door, but the door was folded inwards, which means that when you walk out into that basement hallway, there's nothing obstructing your view. Now, the reason there's only a theory from the trustees' hearing, maybe the reason that Ms. McCartan didn't see it is because she was engaged in some conversation with another officer. But there's nothing that should have obstructed her view, and there's nothing that proves that this is anything other than her own misstep. And under this court's criteria that it laid out in Doyle v. Kelly, if a trip and fall results from the petitioner's misstep, it's not an accident as a matter of law.
So I'm going to ask you, I'm sorry.
Do we know exactly where that object was located in the hallway?
We do, Your Honor, because it also presented during the trustees' meeting was a picture of the hallway with an X indicated by either the petitioner or her PBA representative, which show the location of the object. And if you would direct yourself to page 365, you would see a picture of the hallway with the X.
So my question goes to the tie vote that the board did. I don't know. I'm thinking of a verb. I can't come up with one. So that tie was broken by the commissioner, and as you know, normally when that happens, courts can change that result only if there's a mistake as a matter of law. Where is the mistake as a matter of law?
Your Honor, it's the city's representation that there is no mistake here. You're right. Based on a tie vote for the ADR benefits out of the Board of Trustees, this court can only reverse if they find as a matter of law on the record before it that there was some sort of error. And there's no error that can be pointed to here. Ms. McCartan argues that the Board of Trustees misrepresented her evidence, but she had a PBA rep whose duty, presumably, it was to clear up any alleged misstatements, and that never occurred.
Thank you.
I ask that the lower court's decision be affirmed. Thank you.
I'm sorry, Judge, I did not hear you just now.
where was the mistake as a matter of law? And how are we able to reverse the 6-6 tie that was broken by the commissioner?
Well, the 6-6 tie goes to the city whether the commissioner votes or not. The tie always goes to the city under Scheck, which is a very old case. I think it's from the 60s, Court of Appeals. The issue with respect to the matter of law issue, this court can reverse if it finds that on the facts and the law, either one, the judge below got it wrong. Here, and by the way, in this department, and as cited in our memorandum
When you say
below,
that he got it wrong, do you mean that the judge should have found in favor of the police officer?
yes, Judge, that's exactly what I'm saying. The judge should have found that this small piece of equipment could not have been noticed, that it was not due to willful negligence on the part of the officer. She didn't see it. She tripped over it to her ruin and to the end of her career. There's no way she could have known it was there. She hadn't been in that hallway. I want to correct the prior statement. I meant unoccupied hallway, not abandoned hallway. This court held, and this is cited in our memorandum below, in matter of Carr v. Ward, on the facts presented, it seems clear the police department itself created the condition which resulted in the accident and ensuing injury. Therefore, it seems quite appropriate that petitioner should be compensated for her line of duty injury. So too here. The police department created the hazard that caused her to fall. The judge below failed to actually to apprehend the facts correctly, that it was a small piece broken off a bench and not a 9
I'm
to
sorry, where in the record is established that the police department created the hazard?
This piece of equipment was discarded by the NYPD into its own hallway outside the gym area into the pedestrian area of the hallway.
And that's stated in the record? Because I thought that it was that the gym was undergoing renovation, but I didn't know that it was clear that that's how this piece of equipment ended up in the hallway.
Well, the NYPD has the responsibility for the maintenance and supervision of that area, and they failed to keep it clean. So under that circumstance, even if we do not accept that the NYPD created the hazard, it certainly had an obligation to keep safe hallways and failed to do that. So under that analysis, it's their cause.
Thank you. People v. Alonzo Johnson.
Good afternoon, Your Honors. Shaza Abushi Dalal, Office of the Appellate Defender, on behalf of Alonzo Johnson. The core injustice that we're asking the court to remedy today is the disparity between Alonzo Johnson's 13-year sentence and the 10-year sentence imposed on his more culpable co-defendant.
And why is his co-defendant more culpable than he?
Your Honor, Justice Barrett, who presided over the entirety of their joint trial, during their sentencing said unequivocally, and I quote, "Mr. Johnson did not pull the trigger in the case and did not play the role that Mr. Whitefield did and did not cause the death of Mr. Andujar directly."
Well, we don't know that, right? Because isn't it your client who gave the weapon to the other individual?
That's correct, and the
But
other
we don't
individual...
know that that other individual was the shooter, right? Because no one actually knows who the shooter was. Is that correct?
Your Honor, Justice Barrett, again, who had the opportunity to hear the entirety of the testimony at trial, unequivocally imputed greater responsibility on Mr. Whitefield and said that he was the one who pulled the trigger in the case. And in fact, Justice Barrett...
This plea was part of a package deal, wasn't it?
That's correct. It was part of a conditional package. Unbeknownst to Mr. Johnson, Mr. Whitefield was offered a 10-year sentence conditional upon Mr. Johnson accepting a sentence 3 years in excess of that 10-year sentence.
This all happened in open court?
Two separate proceedings.
In open court?
That's correct.
And so you're arguing that this defendant was unaware that it was a package deal, and that if he didn't accept, or one of the, I think it's three, right? Was it three?
3, but one of their cases was severed.
Okay, so that if one of the 3 did not accept, then it would fall as to everyone. Is that correct?
One of the 2, and that much was clear on the transcript of Mr. Whitefield's sentencing and plea proceeding.
Who pled first?
Mr. Whitefield did.
And so you're saying that your client did not know that it was a package deal?
That's correct. There was no record evidence that Mr. Johnson or his attorney knew that it was part of a conditional offer. And I also
Is there any record evidence that he didn't know? Because one would think that this being a package deal and Whitefield having pled first, that the defendant or his attorney would have known about that.
No, Your Honor, there just is no record evidence that he did know. And there's no explanation for why Mr.
So all you're able to tell us is that there's no record evidence one way or the other, but you yourself really don't know.
There's no record
evidence. The only
evidence.
thing you can tell us today that's absolutely accurate is that there's no record evidence one way or the other.
That's correct. And I can also tell you that there's no explanation on the merits of their case for why Mr. Whitefield
Well,
would
I
be
mean, the
offered.
only thing is that I will say that when Mr. Whitefield is taking the plea, he's told that it's only valid with the understanding that his co-defendant, Mr. Johnson, takes a plea to 13 years today. And the court states that it's a package.
That's correct, Your Honor, and Mr. Johnson, during his plea and sentencing proceeding, is never communicated the same. And I also
That we know of, because we don't know whether his attorney informed him of that it was a package. Is that correct?
on the record, yeah, on the record.
There is no reason to get into the package deal at that point because Whitefield has pled, and now the question is, does Johnson plead or not?
Could I respond, Your Honor?
Please.
Yeah, we would say that there is reason. Mr. Whitefield was adjudicated a second violent felony offender and was the actual shooter in the case. Mr. Johnson was not a predicate and did not play, by the characterizations of the judge who presided over the entirety of their trial, did not play the role that Mr. Whitefield did. And yet, inexplicably, he was sentenced to 3 years in excess of Mr. Whitefield.
And the sentence covered 2 crimes. It covered robbery earlier in the day.
He pled guilty to manslaughter 1 only, Your Honor.
But that encompassed the fact that there was a robbery earlier in the day.
Mr. Whitefield also, it encompassed that as well, so that does little to distinguish their postures.
Thank you.
Thank you.
Levi Stowe for the people, may it please this court.
So how do we reconcile the difference in sentences? And do we have to reconcile the difference in sentences given the fact that it was a package deal?
I don't believe this court has to reconcile the differences. The court is right in raising the issue that the full conversations of this package deal are not on the record. The full conversations of this package deal occurred off the record.
But it was told to Mr. Whitefield. That is on the record.
Pardon me?
The statement to Mr. Whitefield is on the record.
Correct, Your Honor, yes. But there are many reasons where one co-defendant might be offered more or less than another. Whether those reasons are on the record or not, I don't think is operative here.
Are you implying that it's possible that Mr. Whitefield provided some cooperation which resulted in the reduced sentence?
I don't have that information at hand or on the record here, but that would be a good example of a reason why you might see a disparity between offers given in a package deal between co-defendants like this. And if we did see a disparity, just look to the case here. We have a trio of defendants working together. They start their day by robbing someone at gunpoint for what? $12 and a pack of cigarettes. They're not done. They go find their second victim, not randomly, mind you, right? This is planned. It's under the guise of a sale of marijuana. So this trio start with their intent, their desire to steal a bag of marijuana, right? And what's the outcome? It's a man's life. That's a disparity I'd like this court to look at in this case. A person could look at a case like this and they could say that life looks pretty cheap in the Bronx, but life is only cheap in the Bronx when we let people, like the defendant here, set the price. We face that in this case here And we see that 13 years jail and 5 years post-release supervision is a fair punishment for this. The defendant agrees that this is a fair punishment. Quoting here, he says it's the best result. The best result for him in this case.
So is there any basis in your eyes to the language about this has to be a package deal? Because the court did say, let's see, if both cases go away today, that will be my promise to you. This is to Whitefield, that he would get 10 and 5. If not, I will be giving you back your plea. Do you understand? And then Whitefield, the co-defendant, says yes, but as has been clarified, there were 2 separate proceedings.
There are 2 separate proceedings in open court, and while we don't have this in the record for us, we can speculate about how much the defense attorneys maybe spoke with each other or spoke with the prosecutor in the case about determining what this package deal might look like. But I wouldn't want to speculate too far either way on what those discussions might be.
I mean, this sentence resulted upon the reversal of defendant's murder 2 conviction, for which he'd been sentenced to 17 to life. Was that the sentence?
That is correct, Your Honor. And beyond just bearing on the nature of whether this punishment is excessive or not, I think it also bears on the question of the waiver of the right to appeal. Defense argues that it wasn't made clear what his trial rights or appellate rights might be. It was made clear. It was made clear in the oral colloquy. It was made clear in the written waiver. And he also had the knowledge, better than anyone on earth, what the nature of his trial rights were, because he went through a trial on this very case. So he knows what his trial rights are. He knows what his appellate rights are, because he went through the appellate process too. He has the deepest knowledge possible for someone to take when they are taking a plea on their own case like that.
Thank you.
Thank you.
Aren't you, on a certain level, really arguing that Johnson's plea counsel was ineffective in agreeing to this plea without knowing what Whitefield was doing?
Your Honor, I'm asking that this court reduce a sentence in the interest of justice. That's the crux of our ask, and it's really out of recognition of—
I understand that, but when you point to the discrepancy in sentences, when you point to that injustice as a basis for a reduction, it depends on what the circumstances were. And don't those circumstances depend? For instance, if defendant did know that Whitefield was getting 10 years and he was getting 13 years, and nevertheless he agrees to the 13 years, that's really a pretty strong point against the argument you're making here today, is it not?
I can't speculate as to what happened off the record. What I do know is that on the record, there's no indication that Mr. Johnson knew what Mr. Whitefield was getting, and particularly given Mr. Whitefield was the shooter in the case.
We don't know that Mr. Whitefield was the shooter. You've said that before, but I thought that there's nothing, we don't know who was the shooter, do we?
Your Honor, Justice Barrett was as close
Was not
to the
there at the time of the shooting. I don't think Justice Barrett was there. And I don't think there's anything in the record that says that Mr. Whitefield was the shooter. But be that as it may, Mr. Johnson, he had prior felony convictions, did he not?
He did, as did Mr. Whitefield, and again, Mr.
No, I recognize that, but we're talking about Mr. Johnson now. He did have prior felony convictions. He had 2, is that correct?
He had 2, however, they were more than a decade old at that point.
And he also had an out-of-state conviction, I think in Pennsylvania or something like that?
That's correct. Again, the crux of our argument is that their sentences were not proportional, and they both had a record, and Mr. Whitefield was adjudicated a second violent felony offender. Mr. Johnson had no predicate.
Does the record reflect Whitefield's age?
I'm not sure, Your Honor. I believe that they were both around the same age, though, to the best of my recollection.
Thank you very much. Thank you both. Holmes versus the City of New York.
Good afternoon, Your Honors. Lester Channon from Farber, Brox, and Zane for Defendant Appellant 854 7th Avenue, doing business as Stagecoach Tavern. Just at the outset, I'd like to say I wear hearing aids. I have a hearing impairment. If you could lower your masks when you speak, it would be helpful. I would also make one further comment, which is the ventilation makes it more challenging, but I'll try to persevere.
You can remove your mask if you wish.
Yeah, it doesn't, right, my mask doesn't affect.
No, I'm just saying if it
Yes,
makes you
thank
more
you.
comfortable.
Right. Okay, so we represent a tavern, a restaurant on 7th Avenue between 53rd and 54th Street. Acadia owns 7 of the ground floor premises, and one of those is Stagecoach's
Right, so
restaurant.
Acadia leased to Stagecoach.
Right,
Right.
and then they are, there's a condominium that owns the entire building.
Right, and so Section 7C of the lease between Acadia and Stagecoach states that Stagecoach shall not make nor permit to be made any improvements of a structural nature on the premises or any portion of the building, nor any improvements to the exterior or storefront of the premises. Is that correct?
Yeah.
Okay, and so now we're talking about the tree well that's outside of Stagecoach,
Correct.
but it's missing a tree, right?
Yes, and there's a tree guard that,
So we only have the tree guard, and the plaintiff in this case tripped over the tree guard.
yes, he was looking off to his
He was
left.
looking off to his left. And,
Yes.
and tripped right over the tree guard.
Correct.
So the issue is whether Stagecoach in any way is responsible for the tree guard.
Exactly right. And
The
basically,
evidence shows, does it not?
pardon?
The evidence shows, does it not, that it's your client that arranged the removal of the tree guard? I know there's a dispute as to whether you did it because you were asked by Acadia to get it done, or whether Acadia denies that they asked you to do it. But the bottom line is that the actual removal was arranged by your client. Is that right or wrong?
No, that's correct. I mean, right, as you said, their position is that they requested that the landlord do it, the landlord promised to reimburse them for it, so on and so forth. But this is, the rule here, as
That's a post-occurrence rectification of, that's a post-occurrence rectification of a dangerous condition. Is that something we should be considering on this motion?
Yeah, they were extremely concerned about the accident that happened. They placed 50 complaints to the landlord, to the city, prior to the accident about the tree well. Nothing got done, and then, lo and behold, this is what happened. But the plaintiff admits that neither Acadia nor Stagecoach had any obligation to maintain this tree well.
But the fact that you removed it, the question is, you removed it. You removed it post-accident.
Right.
But does that not show that you had some responsibility for it since you ultimately removed it?
I don't think that does at all. In fact, the lease says very specifically that we don't have any obligations concerning repairs.
So why did you remove it? Why did you remove it after the accident? Why then didn't you, if you had the responsibility and the ability to remove it after the accident, why didn't you remove it prior to the accident, where you admit that you made numerous complaints to the city concerning the tree guard?
Well, it's our position that the landlord told us to, or asked us to, agreed to reimburse us for it.
So would you comment? I'm sorry.
Pardon?
You can, go ahead.
So, but under the lease.
That's what I was
under
going to ask you
section-
about, 22. So
Pardon?
under section,
No, well, now I'm talking about section 12.
no, I'm going to ask you about section 22. So it says that Stagecoach was supposed to keep the sidewalk and the curb clear of any tripping hazards.
Yes.
So is it your position that the tree well was not part of the sidewalk?
Yes, absolutely. That's what the Court of Appeals has held, They have, and plaintiff admits, they have neither Acadia nor Stagecoach had any responsibility for the tree well whatsoever until Acadia unilaterally installed the tree guard, whereupon the plaintiff's position is that they then incurred potential liability for their action in creating a potential hazard. How is that possibly retroactively the responsibility of the tenant, who had absolutely no responsibility under the lease that was incepted in 2013 for the landlord's unilateral decision to install a tree guard? Okay? At that point, the landlord incurred potential liability under the common law, not under the statute, and the plaintiff's position is that somehow the tenant may have assumed that responsibility. Where? The lease has an integration clause, and in section 12B, it says specifically that the extent of the responsibility of the tenant is only as required by applicable government regulations. So whatever our responsibilities were, and there were a ton of responsibilities that the landlord held to itself for structural repairs and wear and tear and what have you, many, many things which I list in the brief. But the bottom line is that we had no responsibilities that went beyond the statutory obligations. Well, guess what? The plaintiff admitted we had no statutory obligation, nor did the plaintiff. Therefore, it's impossible that we had a repair obligation to repair a tree guard that is not part of the sidewalk, and specifically under 12B of the lease, not possibly part of our repair obligation.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Rosinas, representing the city co-appellant. Your Honors, this is a case where the photos and the video in evidence are worth 1,000 words. And what those photos and that video show is that this tree guard was open and obvious and not inherently dangerous. It was a jet black tree guard. There was nothing wrong with the paint. There was nothing wrong with the structure. It was standing straight up and down. It was contrasted with the nearly white sidewalk behind it. And although the plaintiffs contend that, well, the sidewalk nearby was narrow or there were pedestrians in front of Mr. Holmes right before he fell, the video shows otherwise. The pedestrians were basically all beyond the tree guard when he was approaching it, and one of them was sort of more or less coextensive with the back end, but he tripped over the front. And as for the sidewalk, you can see Ms. Holmes, the co-plaintiff, walking to the left as Mr. Holmes falls in the video, very easily with no encumbrance. It's not like she's squeezing or anything. And in fact, when Mr. Holmes falls, it's not like he falls into her, which he would have had to do if the sidewalk were really so narrow. So, Your Honor, is there...
I don't know that that's correct. I mean, I've looked at the video numerous times. It's the way he fell. I don't know that you could say that because it was narrow, it was not narrow. Your position, the city's position, is that you did not receive any prior written notice of any defect. Is that correct?
No, Your Honor. Actually, that's not what this appeal is about. We argued that below, but we are not arguing that here. The sole basis for our appeal here is that the tree guard was open and obvious. And to your first point, Your Honor, the reason the narrowness of the sidewalk is important is not so much the way he fell, it's that he could have avoided, what they're saying is, what the plaintiffs are saying is, oh, well, he couldn't have avoided this tree guard by walking around it. No, he very clearly could have. There was plenty of space to walk around it based on what you see in the video, Your Honor.
Right, and there was somebody who actually walked around it to the right. There was a gentleman in front of, well, before him who walked around to the right.
That's right, Your Honor.
Almost into the street, actually.
Yes, Justice Weber. I think he might step in the street or else he's walking right on the curb. I think he steps in the street.
Yes.
But yes, he walks to the right, Your Honor, and Ms. Holmes, again, walks to the left. So it was an avoidable object, Your Honor.
So the motion court denied your application, denied summary judgment based upon your argument at that time that you did not receive written notice. So on appeal, you are now arguing?
No, Your Honor. I mean, it decided both issues, and we pressed both issues below. And on appeal, we're only pressing the second issue. So
That it was open and obvious.
Exactly, Your Honor. We argued that below. The trial court decided that against us below. We're appealing on that basis alone. And the important thing, I think, again, on the open and obvious point, is that the tree guard was very easy to see and easy to avoid. And as for the anti-sit spikes that the plaintiffs make a lot of hay out of, the fact of the matter is those spikes, as long as you can see and avoid the tree guard, those spikes pose no hazard whatsoever. Those spikes are only a hazard if you fall on the thing. But the test, as this court is aware, for whether or not something is open and obvious has to do with whether or not you can see it.
Does the record reflect why you would have the tree guard with spikes? You didn't need the spikes to accomplish the purpose of the tree guard, did you?
Well, Your Honor, the purpose of the spikes is a safety measure to prevent people from sitting. I don't know if that's in the record. It's something I think this court can take judicial notice of. We cited some articles from around the internet and various publications that show that in our reply brief. But the important thing, Your Honor, is that it's kind of a safety measure itself, in fact, because if you look at the photo of the tree guard, the spikes are actually only on the interior side, the side of the tree guard, the side that's parallel with the path of the sidewalk. So what it seems to be doing is it's keeping people from sitting in a way that would put their knees out into where pedestrians would walk down the sidewalk. So, and of course it's true that our witness said, well, we've since decided that these sit spikes are unsafe relative to a tree guard that doesn't have spikes. The agency decided that it prefers that, but the Parks Department, that is. But of course, it's well established.
I'm sorry, was it the city that installed the tree guard with the spikes?
I don't think it was the city that installed the tree guard, Your Honor. But I mean, the question of what the plaintiffs are saying is that the city should have removed the tree guard after it removed the tree.
Yes.
So I mean, the spikes still. I mean, the way this case, the posture at which this case stands on appeal, we're not trying to say, well, we weren't responsible for the tree guard per se. We might say that again later on if this case goes back. But the basis of our argument here is that the tree guard is open and obvious and not inherently dangerous. And again, the point, Your Honor, Your Honors, I think is that the spikes are not inherently dangerous because as long as you can see the tree guard and avoid tripping on it in the first place, those spikes aren't going to hurt you.
I don't know that that's correct, because I think if you're just walking on the sidewalk and you happen to trip, you could fall over onto the tree guard and onto the spikes. But that's another issue. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Kevin McArdle for defendant, respondent, Acadia.
So your adversary made the point that Arcadia was the one who put up the tree guard?
That's correct, they did.
And the spikes?
Well, the tree guard with the spikes, yes.
Okay.
Yes, but there was no tree when it was first installed, and then a tree was installed. And when there was a tree, there was no hazard because the tree served as a visual cue for pedestrians.
The tree was planted by the city, I assume?
That's correct.
So this is one of those street trees?
Yes. Yes, it was planted by the city. It was fine because it didn't serve as any kind of tripping hazard with the tree present. Then the city removed the tree, and then we apparently had a tripping hazard. At that point, it became Stagecoach's obligation pursuant to its lease.
Yes. So why did it become Stagecoach's responsibility?
Because the lease states, paragraph 22, that they are responsible to remove any tripping hazards. We submit that there's a question of fact that this is a tripping hazard that they had to remove. Also, their conduct is consistent with their obligations in the lease. After the tree was removed, they took steps to beautify it. They put in stones within the tree guard so it looked nicer. They put in a Christmas tree. And then ultimately they removed it and paved it over and put down concrete, all consistent with their obligations in their lease, which is why there's a question of fact regarding their responsibility to the tree well. Otherwise, I'll defer to my brief.
Thank you.
Okay.
May it please the court, my name is Brian Shute. I represent Jeffrey and Karen Holmes. Three basic principles of law. Number one, where a defendant is moving for summary judgment on the ground that the condition was open and obvious, the defendant must establish A, that it's open and obvious within the realm of the case law, and B, not inherently dangerous. Must show both. Second principle, every object is, of course, visible once you're looking at it, but under the doctrine, open and obvious, a condition that is visible when you're looking at it, nonetheless, is not open and obvious if A, someone might be distracted, or B, it might be obscured. C, while courts can and have and do resolve this issue as a matter of law, it is, quote, generally or usually one of fact. The first proposition, the cases we cite at page 31 of the brief, including this court's recent decision, Mosera. The second court at pages 34 to 35 of the brief, including Powers. And the third, including the Tagle case, and the others at 35 to 36 in my brief. Now, this case, where you have the tree well with the spikes guarding where the tree used to be. Number one, and this is, you'll see this at page 1131. The CEO of Stagecoach, the party which now alleges this was open and obvious, not inherently dangerous, contemporaneously states, before the accident, 1131, this was a, quote, dangerous trip hazard. He then testifies at page 453 to 454 of the record, yes, that was my opinion, I was correct. And he complained close to 50 times about it, pages 404 to 405 of the record, and had nothing to do with the spikes, by the way. His opinion had to do with all the accidents that were occurring. You could see this at pages, the testimonies quoted at page 12 of our brief. It's at pages 429 to 430
But does that, the fact that they recognized that it was a tripping hazard, they recognized that there had been perhaps prior accidents, does that confer upon them the duty to remove it?
Oh, only if it was within their control.
Exactly.
I'm agreeing with you there. I think when you look at which defendants are responsible under the contract, the cases show, collected in our brief, that you look actually at two different things. One, the contract itself. Two, the party's course of conduct. Even where the contract's clear that the duty is imposed on the tenant, or clear that it's not imposed on the tenant, the course of conduct could lead you the other way. As, for example, last year in the Arias case, which Justice Mendez was on. Here, when you look at the lease, the words tree guard, tree well, of course, are not in it. Each party construes the words sidewalk and structure the way you'd expect them to. But even if it were clear, which it's not, that the obligation is on the landlord, even if that were clear, you have the course of conduct, which is factually disputed. The one thing that we agree upon is that the landlord, in fact, did nothing for a period of 2 years. 2 years, people were tripping over this. 2 years, people were tripping over this. Third, the witnesses from the other defendants in the case, lessor and Orsid, which managed another portion of the premises, they agree it's a tripping hazard. On the, if I could just finish my thought.
Yes, that point.
On the other side of the ledger, no one, literally no expert, no lay witness says that it was not inherently dangerous or that it was open obvious either. The only ones who say that are the attorneys, no witness. If I could briefly respond to two arguments that were raised in the reply brief.
Nope, you ran out of time, but thank you.
Oh, can I just give you a cite then?
Okay.
The city argues for the first time in the reply brief.
That's not a cite.
Okay, but I'm just telling you why this, I'll give you the Hornbook cite. It's McCormick on Evidence, 8th edition, section 264. Also, Prince Richardson Farrell on Evidence, section 8-209, and they both say that you don't need to be an expert to make a damning admission, which, by the way, is why when the plaintiff says it was all my fault, you don't ask whether the plaintiff had sufficient expertise to render an opinion.
Thank you.
Thank you.
Your Honors, I'll allow the city to discuss the open and obvious argument as far as the lease goes. Well, number one, there's no evidence that Stagecoach created this or made a special use of the tree well or negligently repaired it such that it created a defect, okay? So, therefore, they could not possibly be responsible for it with respect to the plaintiff. They did not entirely displace the owner's obligations, and if you look through the lease, the owner has innumerable obligations for wear and tear, structural repairs, fire, casualty, all these things they have to do, on top of which...
So you're saying that at this...
We didn't entirely displace
You're
their
saying at this
responsibility, so
point-
Espinal doesn't apply.
Stop. Thank you. You're saying that at this point in the litigation, we do have enough to grant your motion to dismiss?
Absolutely. Yeah, and the Section H that they refer to specifically has an exception, which is that it only is to the extent as required by governmental regulation. Well, the plaintiff admits governmental regulation doesn't impose any obligation on either Acadia or Stagecoach. So the lease could not possibly have required the tenant to have done anything in this tree guard, which was created after the lease was incepted, yet the lease was never modified to include any additional assumed obligations. Everybody's talking about assumed. They assumed an obligation. How? After the fact, 6 months after the fact, that they removed the tree guard after the landlord told them to. But even if the landlord didn't, even if they were exasperated enough to do that, that doesn't mean that they created the defect, had a special use of that space, or negligently repaired it such that it created, nor did it entirely displace the the landlord's obligation. So
Thank you very much. Thank you.
Okay, thank you.
Your Honor, just briefly, in picking up where our colloquy left off, Justice Weber, I think the reason that these spikes don't somehow, as Mr. Shute suggests, transform this tree guard, which is easy to see and avoid, into something that's inherently dangerous, is pretty clear from the Francini case that we cited on page 8 of our brief. What happened in that case was a litigant was walking down some stairs. She tripped and fell on a stair and fell into a steel trough that injured herself when she hit the trough. And this court said the fact that the trough was there didn't change the fact that the step that she fell on was not inherently dangerous or open and obvious because it didn't cause the accident, and wasn't a foreseeable risk. There was not a foreseeable risk of harm from the trough. I think the same thing applies here.
Isn't there a difference between a trough and spikes?
Well, I think the point, sure, of course there's a difference between those two objects, Your Honor, but the point is that the same principle applies, which is the plaintiff here, Mr. Holmes, the co-plaintiff, fell on one aspect of this tree guard, was injured by a different aspect of it, just as you had a structure here that involved some stairs and a trough. But again, as long as you can see this open and obvious tree guard and there's room to avoid it, there's no reason to say, based on the spikes that have a totally different purpose and that are facing in a totally different direction than someone who's walking along the sidewalk, then will be relevant, someone who's walking along the sidewalk, that doesn't transform this tree guard that is open and obvious and otherwise not inherently dangerous into something inherently dangerous, because you're not going to fall on it, Your Honors. That's the key. If you see this with the ordinary use of your senses, you're not going to fall on it. There's no dispute. When you look at the video, you can see, Your Honors, that there was plenty of room, based on what happened, there was plenty of room to walk, and there was plenty of room to avoid this, plenty of ability to avoid this tree guard.
Thank you.
Thank you, Your Honors.
Melikov versus 65, Melikov versus 66 Overlook Terrace.
Good afternoon. May it please the court, Mark Bernstein on behalf of the plaintiff appellant. This appeal in its present form is from the lower court's April 6th order denying the plaintiff's motion to vacate a March 22nd
Sui sponte order, right?
of dismissal.
Of dismissal.
That
You submitted an affidavit stating that there was an email that was sent to you that had the incorrect date. It stated 3/8 as opposed to 3/1, where the documents or the upload was required. That was the deadline. And your adversary did not oppose your application to vacate the dismissal.
everything you said is exactly accurate.
Anything else you want to add? I think that
What-
should have been a no, but go ahead.
I'm always in a difficult position when I'm taking a cue from the court, and there's a lot. that
I think that's a no. Thank you so much.
Thank you very much.
You're welcome.
Good afternoon, Your Honors. Jason Steinberg. Just want to say one thing. The fact that we did not oppose the motion doesn't mean you can't consider our arguments on appeal.
I understand that, but you do agree that the email that was sent was stated the wrong date, right?
I agree with that. I can't dispute that.
Okay, thank you both. Thank you so much. Next case for argument is 199 versus New York City Law Board.
That was very good.
Awesome. Oh.
Good evening, Your Honors, and may it please the court.
Did you say good evening?
I did.
No.
Don't say that.
No, don't say that. It's 4:20, please.
Good afternoon,
after,
then, Your Honors.
Thank you.
I represent the appellant 199 Dashing. My name is Jason Frosch of the firm Cooker, Marino, Winiarski, and Bittens. In this case, the Loft Board decided to, without authority, deviate from the Court of Appeals holdings in Mahoney-Buntsman versus Buntsman and this court's consistent application of that doctrine to a variety of contexts.
So we're talking about the tax returns, basically, right?
Yes, this is a case in which a tenant claiming rent protection deducted rent on their business returns for about a 5-year period or 7-year period.
Studio expenses, right, or expenses?
No, this is just like the fact pattern in Ansonia versus Unwin, Goldwater versus Amicus Associates, and Brookford versus DHCR, in which these deductions were made on both the 1120S forms of their S corporation returns on line 11 and on their Schedule Cs on line 22.
So counsel, I found it most curious that the tenants listed their address not as the address of the subject premises on their tax returns, but rather an address on Grand Street in Brooklyn. And the company listed the loft as its address. How do you distinguish this situation from Goldwater, where we decided in 2019 that a plaintiff who deducts rent and utilities on his federal income tax returns for his S corporation cannot demonstrate that the unit was his primary residence?
Yes, I think that that's a question that needs to be asked to the Loft Board, because the Loft Board does not provide any rational basis for distinguishing the Goldwater case from this particular case. It's the same. Now, the address issue, I think, is irrelevant, and there have been several cases where litigants have argued that the address is somehow significant because putting a different mailing address on the 1040 return form somehow indicates that's the residence. No, my client has not argued that at any level in this case, although the city attempts to strawman that by saying that seems to be the issue. The address on the tax returns is irrelevant. What's relevant is for which premises was rent deducted as a business expense for the S corporation and for the sole proprietorship. And so what the Loft Board is doing here is saying, although everyone else has to comply with Mahoney-Buntsman versus Buntsman and this court's holdings in these cases on rent regulation, for some reason loft tenants are exempt from that. And
Well, the Loft Board said, you know, it makes sense that they didn't list it as their residence on their tax return because the building did not have a residential certificate of occupancy, so therefore they couldn't have really listed it as such.
Okay, so there's two reasons why that doesn't make any rational sense. The first is that the very statute enabling the Loft Board, the loft law at Multiple Dwelling Law Section 283 says, notwithstanding any other provision of law, occupancy for residential purposes of residential units covered by the loft law is permitted. And that took effect in 2010 before this trial and during the period of time, or prior to the period of time when these deductions were made.
So counsel, before you run out of time, could you just speak about the hallway, the issue in terms of that hallway?
What I just want to briefly say, and most importantly, although a tenant might be tempted not to list it as their residential address, that has nothing to do with deducting rent as a business expense on their tax returns. It's simply irrational to that issue. The hallway issue is just an issue of practicality. The hallway was an access area for the landlord to routinely maintain the elevator, and it's where the mechanical room is located. And the Loft Board granted...
It wasn't included in the lease.
It wasn't included, well, the lease says the second floor, but the second floor premises was always understood to not include, for example, the public hallway in the front of the building, and it shouldn't have included the rear hallway in this situation, since that's an access area that the landlord super routinely utilized to maintain services in the building. For some reason, this wasn't even pled, and it was added in the middle of the hearing.
But wasn't there something that said that the landlord had not actually been using that hallway for a period of time?
No, the landlord super testified that he was utilizing that space. It's just that the trial judge did not find that to be credible.
The elevator opened into that hallway, didn't it?
Yes, the elevator and the machine room
And
for the
the
building.
mechanical room.
That's right. And so I just note that without any justification, we've asked the Loft Board at every level of this case to provide any other reason why they can exempt loft tenants from the same doctrine that applies to every other rent-regulated tenant pursuant to this court's consistent decisions and the Court of Appeals decision. They have not provided a single rational explanation for why they are entitled to allow tenants to deduct rent and make logically incompatible claims in their coverage claims.
Thank you.
Thank you.
Good afternoon again, Your Honors, and may it please the Court. I'm Alan Racinas, representing the New York City Loft Board, one of the co-respondents. Your Honors, the most important thing to recognize in the main issue here is that the relevant year for determining whether these tenants should get protected occupancy status is 2014. And if you look at the record, pages, actually I forget the pages offhand, I had them a moment ago, but our brief cites in the record that the 2014, the tenants filed their 2014 individual federal and state tax returns with this loft as the address.
But I thought they were still deducting in 2014. Weren't they still taking a deduction as business deduction for the premises in 2014?
I think that, yes, that's right, they were, Your Honor, but the
That doesn't count. I mean, they also deducted the rent on the loft as a studio expense pertinent to Handmade the company. All of that time before. Are we supposed to, is the Loft Board closing its eyes to that?
No, Your Honor, but the question that Ansonia and the related case law raises is whether the filings with the IRS are logically incompatible with the contention that the tenant or the party, and so it's not a tenant-landlord dispute, that the party lives at the address in question. But here there is no logical incompatibility because they filed...
Is it legally compatible with the tax code?
Well, no, that's right, Your Honor. The rent deduction is not compatible with the tax code, but the question is not that, we would respectfully contend. The question is whether or not there is logical incompatibility. And when you file something, a personal return that says, I do live here, there's nothing logically incompatible between that tax return and the other tax return taking a rent deduction, nothing logically incompatible with sorry, not between those two
Just
things,
that
but with
both
the,
positions can factually coexist.
right, well, in other words, there's an error somewhere, Your Honor. And I think the most logical inference is that they didn't understand that they couldn't take rent deductions on the business tax.
All these years, they didn't understand that. Do we draw any parallel, or can we draw any parallel with the rent stabilization laws, which would be in opposite to these, this practice?
I mean, Your Honor, I think there's nothing inconsistent here, again, because of the factual distinction. Even if you're looking at Ansonia, where the rent stabilization laws were the key issue, there's a key factual distinction here in that.
One second, I'm sorry. There's a key, what's the key factual?
In that there is this IRS personal filing about where they lived and saying that they lived at this loft at the pertinent time period.
I'm just floored by the logic that you're asking us to consider. I mean, the ETPA applies to residential loft tenants, and that's as of 1983. All of that time, since all of that time, the rent stab provisions have applied, right? And you're saying it doesn't make a difference if someone puts one thing on their tax returns and is actually doing something else for purposes of gaining the coverage of the loft law. I mean, again, the question that I asked your adversary, how does that square with Goldwater, which says that you can't do this? And how does that square with Mahoney, which says that a party to a litigation can't take a position contrary to a position taken on an income tax return? What is the law board doing?
Well, Your Honor, the point here is that in those cases, there was no tax return that said that they did live at the pertinent address. Here there is. There are federal and state returns that say that they lived at the proper address, at the address they say they did.
It says they lived at Grand Street.
Not for the year in question, Your Honor, which is 2014. I think I remember the citations. I think it's 3303 and 3305. The relevant year here is 2014, not 2008 or 2009. The Grand Street mistake or the Grand Street error was, however you want to characterize it, the Grand Street representation in the tax returns was earlier. It was 2008 to 2011, I think. It was not 2014.
So you have no look back.
Well,
you're taking 1 year in isolation and you're saying, forget about what you did before. Now at the point where you come to us, it's okay, because you really didn't understand what you were doing?
Well, the protected occupancy provision is about current residency, Your Honor, current and potentially through the administrative hearing. There's one case, there's one law board decision that the landlord cites in its reply brief that says you look at the whole record, but the context of that is they're saying in that case, the tenant lived at the loft when he applied, but then admitted in hearing testimony that he moved out. Certainly the testimony that, or moving out of the loft afterwards may be relevant. But yes, the relevant time period, as we say in our brief for protected occupancy status, is when you apply and potentially thereafter.
And that was 2014. Thank you very much.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Robert Petrucci. I'm here for the respondents' tenants. If I may, Justice Gonzalez, I'd like to answer your question. The loft law that protects these clients was not even effective until June of 2010. The landlord is attempting to impose conditions on their occupancy prior to the effective date of the law. All of these units, all of these IMD units, by definition virtually, were commercial in nature. There was no residential certificate of occupancy for them. They were living there illegally. The legislature recognized this illegal use and passed this law separate and apart from the ETPA or rent stabilization to bring these units under rent stabilization in the future after they've been registered and legalized. That has not happened here. It still has not happened here, and it did not happen during the entire time of the hearing. Also, because these units are by definition residential and commercial, my clients were perfectly entitled to deduct some portion of their rent. as a business expense. They may have not done it in the proper fashion, but the statement that they made, that they deducted 45% of their business, is not inconsistent with living in the other percentage of the space. These units are to be legalized by Article 7B, which is titled Joint Live Work Quarters for Artists. So the legislature contemplates shared commercial and residential use of these spaces. So there was nothing inappropriate that they never deducted 100% of their rent. They may have filed the wrong form, but that is not a basis for an inconsistent statement. That's illogically incompatible, or logically incompatible with what they said on their tax returns. As far as the hallway, that the tenants had exclusive use of that hallway since 2009, when they rented the entire floor. The landlord only came in by permission. Yes, there was an elevator in there that the landlord occasionally accessed, but that only served the tenants.
But you just said they had exclusive use. I thought also the landlord had, because the mechanical room was there as well.
But there are plenty of cases where a tenant, say for example, rents a basement, but the landlord has some utilities in that basement. That doesn't mean that the landlord has exclusive use of the basement. The landlord just basically has a right to go into that particular part of the basement or to use that particular facility.
So was there anything that presented that to the in the record stating that in order for the superintendent or whomever to gain access to that hallway area, they had to secure the consent of your clients?
The doors were locked. They couldn't get in.
But I thought the elevator opened up.
Yeah, but the elevator hadn't been used since many years before the effective date of the loft law. And also the percentages that the landlord is saying in the briefs are their own adopted percentages, not the ones that the loft board found, which are found in the loft board's report, in the ALJ's report and recommendation. That's where the accurate percentages are found. So the deduction of a part of the rent is not mutually exclusive with using part of the space as a residence. And there's no question, because the landlord's sole fact witness admitted that they live there and only there. So there's not even a factual dispute about their primary residence. If there are no further questions, I'll rest on my brief.
Thank you.
Thank you.
I think it's important.
Well, counsel, given the fact that we have to give we normally give great deference, right, to an agency's determinations, and we would have to find that the loft board in this instance the decision was arbitrary and capricious. So how would this be arbitrary and capricious?
Well, I think it's not only arbitrary and capricious, but an error of law. And the standard here is the agency must have a reasoned explanation when this is a matter of statute and plain language of a regulation. Not only that, this is the binding authority of this court and of the state of New York under the Court of Appeals decision. So this is not a situation in which the loft board is entitled within its limited jurisdiction to grant policy. This is the word primary residence is in the statute, in the loft board's regulations, is in its decisions requiring that primary residence be established by a protected occupancy claimant. That's the very same language that was interpreted by this court in all of the cases I've referred to. And moreover, the loft board has itself applied in peri materia the rent stabilization code provision that is used to determine primary residence in the context of rent stabilization. It's that very same provision that this court said, regardless of the fact that it says no one factor is determinative, we look at the totality of the circumstances, we don't even reach that examination where there are claims made under sworn statements filed with tax authorities that are logically incompatible.
What's the basis for upsetting the loft board on the elevator, on the hallway?
It's a substantial evidence review where there were no documents that were filed either way. It was the testimony of the tenant that contradicted the testimony of the superintendent, who's not an interested party, and the loft board erred in affirming the ALJ's credibility determinations, which, by the way, I'll note, she found neither party credible, and yet for some reason found that that space, which is a hallway that was just used for storing items by the tenants that's not within the main space, as being a part of their IMD unit. I want to focus.
What about the argument that there's no look-back period? The only relevant period is the point in time where is 2014.
Yes, I've cited to numerous loft board orders in which they look at other time periods other than merely the year in which the application was filed. And in fact, even Corporation Counsel notes the Hughes case contradicts with this position, where at the time that the case was filed, he was living in the space, and then afterwards during the hearing, he admitted that he had moved out. The loft board also determined in an order of Mariner Smith, which I rely on heavily in my reply brief and also in my underlying brief and in the underlying case, the loft board found that a person who had various documents from prior to the date of filing that demonstrated that she was residing elsewhere and then amended them during the trial and right before the trial to change that, that those documents couldn't be credited and that the indications on her documents from the prior period were of the basis for excluding her from protected occupancy.
Thank you. Thank you, Bo.
Thank you.
Oh, three of you. Thank you. Meadow Apartments versus S&H LLC.
Good afternoon, Your Honors. May it please the Court. Malab Badoui on behalf of the plaintiff appellant. A court should not make credibility determinations on a pre-answered motion to dismiss. A court should not make findings of fact.
But is it enough for you, after all, the sponsor, owner of the garage lease, comes in and says, I served this in 1992, right? And he produces a copy of the letter he allegedly sent at that time. Is it enough to create an issue of fact for you to present witnesses who say, I don't recall ever getting that notice?
Your Honor, I'm very glad you asked that. First of all, it is not our burden. The sponsor put that letter forward and said, and the court and the sponsor said, prove it isn't authentic. It's not our burden to prove it isn't authentic. The sponsor must prove that this piece of paper is undeniably authentic. It is their burden to do that.
Did you raise the authenticity issue below?
Of course, absolutely. We disputed it, the authenticity from the beginning, always. That's always been our arguments. That was the purpose of submitting the affidavits, was to dispute its authenticity. We say it wasn't received. We say it wasn't in the files. That is disputing its authenticity, and Your Honor.
You don't really mean authenticity, which I think they challenge whether you raised it. You mean whether it was mailed.
Well, we didn't outright say that we believe this letter is of suspicious origins because we felt that was distasteful. What we were saying is, we don't know where this came from. It's not in our files, and no one in this co-op recalls receiving it. We don't think it's legitimate. We dispute its authenticity. And, Your Honor, even if we hadn't made that argument, it's a purely legal argument, and this court has ruled on numerous occasions that purely legal arguments that you can decide based on the record can be made in an appeal anyway. And if I may quote Your Honor, in a decision from the Colchin's decision, in that case, this court decided that emails were documentary evidence, right? And in that case, Your Honor said, plaintiff makes no claim, this is Justice Friedman, Your Honor, plaintiff makes no claim that documentary evidence before us gives a picture of the negotiations that is in any way inaccurate or incomplete. And in that case, this court ruled that emails were documentary evidence, but then you decided that the emails didn't indisputably refute the plaintiff's claims. Well, that's not the case here. We have a letter that is of disputed authenticity, and it should not have been considered documentary evidence. But even more importantly, there's been a lot of talk about the letter. In the trial court, there was a lot of talk about the letter. Even if the letter was sent, sending a letter 20 years too early doesn't mean anything. That letter doesn't prove that the sponsor lost special developer control in 1992. The only documentary evidence out there that the sponsor
Can you explain
submitted.
what the meaning of special developer control is in contrast to board control?
Absolutely. Board control is merely one factor in determining special developer control. Special developer control is a broad encompassing term, a broad term that means any way that a sponsor can control or direct the co-op. And the reason for that, the broadness of that term is, If a sponsor can control the co-op or direct the co-op, it can frustrate any attempts by the co-op and the shareholders to terminate a lease.
But that term is not defined in the statute, is it? It's not in that condominium cooperative anti-abuse statute. It doesn't use that term.
It does not, and the case law has developed that term to mean something much broader. But the statute doesn't say it means board control either. Courts have said, federal court, Darnett Court has said that it does not mean board control. That much is clear. That is just one of the ways you determine whether a sponsor has special developer control. And the only document that the sponsor submitted to prove that it lost special developer control in 1992 were offering plan amendments. That's it, just the offering plan amendments. We concede the offering plan amendments say the sponsor lost board control, the sponsor lost board control, the sponsor lost board control. But those very same amendments also say that the sponsor designated 3 of the 5 members on the board. You can't rely on that documentary evidence. And even, even that aside, even if the offering plan amendments were consistent, they were not conflicting, it only proves that the sponsor didn't have board control, not that the sponsor didn't have special developer control. And no one has even touched that topic. Not in the trial court, it's not in the briefs. We are the only ones that are making that argument, and everyone has ignored that. The special developer control point is critical. And sending it, this argument has been made. Sending that notice, that 1992 letter, even assuming it was sent, sending it 20 years too early does nothing. It doesn't shorten the statute of limitations in any way. It must have been sent within 15 days of the sponsor losing special developer control, and it wasn't.
Thank you.
Good afternoon, Your Honors. Michael Hemway from Gartner and Bloom on behalf of the respondents and cross-appellants. Before I get into the arguments of my esteemed colleague, let me just redirect the court to some of the true issues at hand. This case is about a cooperative corporation's untimely attempt to terminate the sponsor's lease for certain...
It's untimely if, among other things, you actually sent that letter in 1992. And isn't counsel right that you have the burden to establish that you sent that letter? And how do you establish that? What's the nature of your proof 20 years, more than 20 years later, when you're called upon for that proof?
Sure. So, Your Honor, the sponsor affirmed in an affidavit that the notice was sent out on December 8th, 1992. He authenticated his signature on it, and he put it in the mail and mailed it to all of the shareholders in the cooperative. And there's been no testimony or evidence to refute that the notice was not received.
Well, it's refuted in the sense that the co-op says, we don't have it in our files. And individual shareholders say, we don't recall receiving such a letter. So you, of course, could have had, you could have had a certificate of mailing, you could have had certified mail. I understand you're not required to, but now you come up 20 plus years later where this becomes a pivotal issue, and how is it to be established?
Sure, so you sort of answer my question.
Because, after all, wouldn't the logical thing have been to, when hearing about the fact that you're out of the picture, your client is out of the picture, you would have opted to terminate the lease?
Sure, so let's take a step back. This is almost 30 years to the day that this letter was sent. There's no requirement, like Your Honor said, to maintain it, and there's also no statute that I'm aware of that requires records to be maintained for 3 decades. The advisory notice was sent, and there's been no evidence
So that notice has to be sent after you've surrendered special developer control, is that correct?
That is correct.
So, first of all, what is special developer control? I asked you the same question I asked your adversary. What does special developer control mean in contrast to board control, because the terms are not defined in the relief statute. What does it mean, and how did you establish that?
Sure, so special developer control is a statutory term, and it's defined actually in 15 U.S.C. 3603, subsection 22. There, it defines what special developer control is. Board control is something that is separate from that. And the advisory notice was sent, even though it was not required by the statute, because within 15 days, the sponsor released special developer control, which was defined in the act. And at that point, the sponsor no longer controlled a majority of seats on the board, and no
So
longer...
you say that the statute has an actual definition of special developer control?
Correct.
And again, what's the citation for that?
Sure, it's 15 U.S.C. 3603, subsection 22. And it's two sentences, and I can paraphrase it briefly. It goes through any right arising under state law, cooperative or condo instrument, association bylaw, charter, article of association or incorporation, or power of attorney or similar agreement through which the developer may control or direct unit owners, association, or executive board. And when that notice was sent on December 8th, 1992, at that point, special developer control by the sponsor was released. At that point, the corporation had 2 years to terminate the lease, up until December 8th, 1994. They did not do that, and they're trying to terminate it over 2 decades later, which is way beyond the statute.
Thank you.
Thank you.
Your Honors, I will be very brief here. The fact that we're now 30 years later, 20 years later, has been brought up repeatedly. It was brought up in the trial court. It doesn't matter if 2 years have passed or if 49 years have passed. The fact is, when was special developer control lost? That is what we need to look at. Just like the sponsor kept the lease, they should have kept this letter. It's of critical importance. Anything related to the lease or the viability of the lease should have been kept. We shouldn't give them a pass on a 3211 on the standard, on their burden, just because too much time has passed. That's not the way it works. With respect to special developer control, even assuming what they say is true, that they lost board control in 1992, which they did not, and we know they did not, and we have in the amendments and an affidavit that say they did not, that is just one of the things, one of the ways that a sponsor can have special developer control. The Darnett case and other cases out there say that. It's broad. If a sponsor, for example, has veto control, can veto the decisions of a board, even though it doesn't control the board, if it has veto power, some bylaws say that the sponsor has veto power, that is special developer control. Cases have said that. If a sponsor can control the finances of the co-op, if in any other way a sponsor can figure out a way to control the co-op, to frustrate their attempts to terminate the lease, that's special developer control. It's a very fact-intensive exercise. And there's been no response to any of that. They had the management agreement. They controlled the finances of the co-op. They controlled the maintenance of the co-op. They did everything. They were the co-op. The co-op was the sponsor was the co-op until 2019. And that's when everyone realized, started uncovering all the things that the sponsor had been doing. And they discovered all sorts of inequities. The sponsor, well, I don't need to go into that, and you know, that's all in our papers, but there's a variety of things that the sponsor did that were not okay. And the co-op is discovering these things as we go forward and as we get files, and I'll just leave it at that.
Thank you so much.
Thank you.
Children's Magical versus Merrill.
May it please the court, Andrew Goldenberg for appellants David Marome individually and David Marome as president of the Horizon Group. Your Honors,
So I'm unclear from the record, and I've read the briefs a couple of times. What is the relationship between David Narum and this Lot 19?
David Marome is
Marome, excuse me.
David Marome is the owner of Lot 19. There's a related action before.
Okay, so he's the owner, because according to the record, Lot 19 was purchased by, I think, 157 LLC?
Right, 157 LLC is the registered owner. David Marome is a member of 157 LLC.
So he's the owner of Lot 19?
Indirectly, yes, Your Honors.
Indirectly, okay.
Yes.
So the issue apparently is whether or not the Children's Magical Garden, Inc., as a licensee of lots 16 and 18, whether they can maintain a trespass action.
As a licensee, that is exactly the issue here. It's a standing issue.
Okay.
So CMG is a licensee, plain and simple. A licensee does not have possessory interest in property. The city is the owner of lots 16 and 18, and only the city, not CMG, can maintain an action for trespass.
Well, I got to ask you an ABC question. So what gives your client the right to build a fence and create encroachments?
So, for the record, my client didn't build the fence. It's alleged that he's maintained the fence. He bought it as the fence as is. And there's an encroachment. But the point is, it's not what gives him the right. The question here is, who has the right to sue for that claim?
So you're saying your client can do whatever he or it wants, and they're untouchable unless you're the city of New York?
Not at all, Your Honor. He's not untouchable. No one's untouchable. What I'm saying is we need to follow the law. And so the threshold issue for every case is standing. And that's your pathway to the courtroom, right? That's how you get there. And so the first thing you have to ask is, what do you need to prove for trespass? You need to prove possession.
So they've had this garden, this community garden, has had possession since 1982, according to the affidavit of Ms. Temple.
Your Honor, they don't have possession since 1982. They've been granted licenses.
Okay, so let's look at the license then. The term of the license. The license says that the licensee, which are plaintiffs, have the exclusive possession and use of the site, except as otherwise herein provided. So it says that they have exclusive possession and use of the site. Why then would that not give them possession of the site?
Right, so Your Honor, you're focusing on one license, that's the 2020 license. That license says exclusive possession. In that same clause, it says that we are not going to lease anything to you. That same license agreement incorporates a rule, it's statute, the Green Thumb Rule, section 6-03, subsection E. It says that any licensee that's given a license under this Green Thumb program does not have an interest in the property. You need an interest to sue for trespass.
You need possession. Don't you need possession?
You need a possessory interest,
Yes.
Your Honor. And so without an interest, if Your Honors were going to rule that a licensee, which CMG is indisputably is, if you're going to say now licensees have interest, where there's case law going back 100 years that licensees don't have interest, this would redefine what it means to be a license. It also would redefine what it takes to allege trespass. An essential element of trespass is possession. They don't have possession because they're a licensee.
So the license for 2013 and the license for 2016 says the plaintiff is allowed use of the site, and there, as you're right, there is no lease clause. So you're saying that you can, your client can impinge on the license?
Again, Your Honor, that is not what I'm saying. I am saying that if someone wants to sue for trespass, they have to either be an owner, a leaseholder, or an adverse possessor. They have to show possession.
You're saying that only the city would be able to sue for the trespass?
Only the city as the owner would be able to sue for the trespass. If the city wanted to maintain that action, it could. It's clear-cut what you have to show for trespass. And I understand the optics here. I get it that we have on the one side, we're called the Grinch developer. On the other side, we have this
It's not a question of optics, at least for me. It's a question of the law.
100%.
And whether or not the plaintiffs have a possessory interest in lots 16 and 18 or not.
And they don't, Your Honor, because they are licensees. We cite to case law
Unfortunately, there's not one case that either side could cite to in this jurisdiction, but we cite to a case just issued by the Ninth Circuit a year ago. It found exactly that someone was a licensee. This is the Gonzalez case we cite in the reply brief. Someone was a licensee, and they
Did you just say the Ninth Circuit?
I did, Your Honor, because
Is the Ninth Circuit on the other side of the world?
it is, Your Honor, and as I mentioned, this is actually an issue of first impression as far as do licensees have standing to sue for trespass. If Your Honors would find that, you would be redefining what it means to be a licensee and what you have to show to prove trespass. It's their burden, not ours, and it's a standing issue, a threshold issue.
Thank you.
Benjamin Burry for the plaintiff respondent, Children's Magical Garden. We submit that the Supreme Court correctly granted a summary judgment on our trespass claim. The court did that on two bases. There's two bases for possession here. There's actual possession of the premises, and there's also the licensee possession pursuant to the instrument you're referring to. As a matter of actual possession, that means what you think it means. Who is actually in possession of the property? As the Supreme Court held, that's a question of the garden being physically in possession of the property, and that's the basis on which they can sue for trespass. The court follows the Beardsley decision by the Court of Appeals more than a century ago, and that decision is extremely on point. There, the court holds the actual possession is established because, quote, plaintiff was and had been from before the acts of the defendant complained of in possession of the land. That's it. And defendant there made a similar argument.
How do you come to be in possession of the land?
So it can really be through anything as long as you're peacefully and lawfully in possession of the land. So Beardsley was a case where the defendant, like here, said, well, plaintiff was wrongly in possession of the land. They said that 5 of these acres, they were carved out from a prior deed. Plaintiff was wrongfully there. The court says that doesn't matter. The point is, you're not going to favor a criminal trespasser over someone who is lawfully, peacefully in possession. What the court said is, nevertheless, the plaintiff had been in possession and occupation of the 5 acres along with the rest of the tract.
But are you actually in possession, or do you only have a license?
So to be clear, we've been on the property since 1982. There have been 3 brief license periods.
And what's the authority for you being on the property? Is it not the license that the city has granted you?
It's through a variety of means, the city we've always worked very closely with the city. We have a close relationship with the city. The city supports this community garden very strongly, and it's always been with.
But your right to be there at bottom is that you have a license from the city.
We have we're there lawfully and peacefully with the consent of the city. And that makes our
under
rights.
a license that's been issued to you or not? Are you squatters? Do you have squatters,
No.
right?
So there, in the 2020 agreement is the one in effect now. That's the one in the record. It expressly revokes all prior agreements and sets up that we have the right to exclusive possession. That's paragraph 3. It says we have a possessory interest.
But it's not a lease.
It doesn't have to be a lease. That is one basis for a possessory interest, that we have a right to exclusive possession of the premises pursuant to a written contract.
So let me ask you a different question. So we're familiar with what community gardens are, right? And your adversary is saying, oh, First Department, are you about to create new law? Are you about to set off on a different path? Is your argument as to licensees and their standing right, their standing limited to this particular context, these particular circumstances, or are you saying that across the board, all licensees have standing to challenge an alleged trespass?
We're absolutely not saying all licensees always have standing. What we're saying is whether someone's a licensee or a lessee makes no difference whatsoever to their rights. They have actual possession of the property, which, for example, the Domhoff case says tilling the soil and raising crops is actual possession.
You say that you have actual possession, but where does your right to actual possession come from?
We have superior rights to the criminal trespasser by virtue of the fact that the city.
Because you have a license.
Yes, that would, in this case, that is sufficient because the city has made clear that defendant's a criminal trespasser who needs to be removed and that the city supports us being on the property. And so the idea
The
is,
city has not made that clear, because I did not see anything that the city had engaged in any action against the defendants for trespass. But the bottom line is that you have a license, and your argument is, as a licensee, you have a superior right, you have possession, you have a possessory interest, and therefore you can maintain an action for trespass.
right, the burden is on defendant. The criminal trespasser has the burden to show his superior rights. It's not our rights that are on trial, it's his, because he has not shown superior rights. That's the Beardsley case, New York Court of Appeals. He has not shown superior rights. He is liable for trespass.
But you're the one seeking to hold them for trespass, isn't that so?
We're seeking to have them removed from the property and have the garden reinstated.
So why is the burden on him?
That's the ruling of the New York Court of Appeals in Beardsley. That's what the Domhoff case says.
Don't you have to show that there was an intentional entry on your property without justification or consent?
It's an intentional entry onto the property of another without consent.
Right.
That's what's happened. He's built a fence onto
But
the,
again, we're back to the same issue. You have to show that it is your property. And
We do
in
not.
order for it to be your property, you have to have a possessory interest in that property.
we do not need to show it's our property. I would point, for example, even to the Wiersbeck case, the defendant's site. That case involved 3 plaintiffs.
You say that the city supports you, but yet the city isn't here.
Well, the
It's
city has,
they own the property, from what you've said.
and to be clear, the city has sent 3 demand letters to defendants, which are a part of the record, in 2016 and twice in 2019, demanding that he remove his fence from the property. They conducted an examination. They said, it's over the line. You need to remove your fence. The Parks Department is of very limited resources. They manage millions of square feet of parks. They don't have the ability to spend 3 years litigating a trespass case on every single one of these gardens. They rely on the community garden organizations that are stewards of these gardens to operate them, to maintain them, and the community garden organizations are the ones with the real interest in the property here. The community garden organization.
Thank you.
Your Honors, I want to just address Beardsley for a second, okay? Before we get to who has superior rights, we have to go back to the elements of trespass, possession. So before we get to, does Mr. Marome has a superior right, it's their burden, Justice Friedman said, it's their burden to show possession. They cannot show it because they are indisputably a licensee.
What about constructive possession?
There is no constructive possession here, Your Honor. The argument that
Why is it not constructive possession?
if I may respond.
Please.
So I think this addresses some of the points they made. Merely being present at the garden, why are they there? They're there because they have a license. Me being present here does not give me the right to sue for standing. Operating a business does not give you the right to sue for standing. Why? It would undo the hundreds of pop-up stores that have come on for Halloween and now are coming on for the holidays. They're all granted licenses. They don't have interest. They don't have standing to do anything. The only parties that have standing
So if
in
someone
New York,
entered one of the Halloween stores, they could not prosecute for trespass?
the landlord or the owner would have standing because the landlord or the owner or a leaseholder has absolute control. Absolute control is what you need to show possession. So there is no absolute control here, right? Because we have a license where the city can come in at any time. The city is telling the garden what it can and cannot do. It has to run educational workshops. It has to have public community events. It has to abide by a 100-page gardening handbook. These are not examples of things that a landlord or owner would put on to a lessee having absolute control. And a lessee would never agree to something like this. It's not a lease. It can't be a lease.
So what you're saying is that we have to look at this within the context of a community garden?
No, Your Honor. You have to look at this in the context of what it means to be a licensee in New York. And there's case law after case law that says licensees do not have possessory interests, and you need a possessory interest to sue for trespass. Thank you, Your Honor.
Schuman versus New York Magazine.
May it please the court, my name is David Boyes and I represent the plaintiffs. The defamations that are claimed are summarized at paragraphs 83 to 88 of the complaint. And we set forth there 6 categories of alleged defamation. With respect to all 6 of them, there are 3 basic issues. With respect to one of them, there's an additional issue. With respect to all of the defamation claims, the first question is what law applies. We've said Massachusetts law, they say New York law. We believe that we've met the standards under either New York law or Massachusetts law. With respect to the standard, the question is it negligence or is it gross irresponsibility? We believe that it ought to be negligence because we believe these are private parties, that's conceded. We believe that most of the defamation, perhaps all, but certainly most of the defamation, does not raise any matter of public concern. It is a matter simply of private concern. Even if this were a case that required gross responsibility, we believe it is clear that that has been pled. And I emphasize to the court that this is a motion to dismiss. This is not a trial. This is not a motion on summary judgment. This is a motion to dismiss, as to which time all of the well-pleaded facts have to be taken as true. And there is no doubt that the complaint itself proves, if you accept what is said in it, that there was defamation and gross irresponsibility. What happened is the court below used certain documents that were submitted to reach the conclusion that there was no reason to doubt the veracity of Mr. Hay. And that's critical because, as the defendant accepts, only if there was no reason to doubt the veracity of Mr. Hay is there any chance for them to win on account of gross irresponsibility.
But wasn't there more? I mean, wasn't there also test evidence that the publication had reached out, had checked the sources, and also had spoken to other individuals?
Well, first of all, there were 2 articles. With respect to the second article, there was no fact-checking. But just the fact that they called up people is not enough. If that were sufficient, it would, all you'd have to do is call up 7 people and disregard what they say, and you would be free from any claim of defamation. What the law requires is that for gross irresponsibility, is that they follow the procedures that normal, responsible people gathering and disseminating information would ordinarily.
So, counsel, I don't see where the deviation was from the gross irresponsibility standard. So we know that it requires that a publisher use methods of verification that would reasonably be calculated to produce accurate copy. And here, the use of a fact checker and the consultation with individuals and the source, Mr. Hay, and the fact that, and I would note this, that the defendants declined to be interviewed. How does all of that together, appears to be the regular standard by which journalists practice?
But Your Honor, the complaint details, in great detail, the facts that were presented to them that demonstrated that this was not true. And it wasn't, and the defendants, the plaintiffs didn't not be interviewed. They presented all sorts of information.
Where? What is it? Because I don't think it's part of the record. How do we assess the veracity, the quality, the character of those documents that were submitted to the fact checker and the author of the articles? How do we know what they say? I mean, you're asking us to rule in the abstract. We have nothing to review.
You don't on a motion to dismiss. That's the problem. This is up to your honors on a motion to dismiss. None of this has been examined. You don't have any testimony. You don't even have testimony or evidence that the reporter believed it. That's
Was
not been
this
subject to
information,
cross-examination.
excuse me,
There's been no
was this
discovery.
information provided to the court below?
Yeah, in the complaint. This is the motion to dismiss.
No, I know what it is.
It's in the complaint.
I know what it is. I'm asking you, the documentation that you're referencing, was it provided at all to the court below by way of opposition to the motion to dismiss?
Not other than in the well-pleaded allegations in the complaint, because under the motion to dismiss, what you're doing is you're testing the complaint. There's never been a case, Your Honor, where you have a well-pleaded allegations in the complaint, and you don't have undisputed documents that refute it. You know, where the defendant wins on a motion to dismiss, maybe on summary judgment, maybe after there's discovery, maybe after we have an opportunity to examine people under oath subject to cross-examination. But at this stage, all you have is the publication and these other documents, the veracity of which we dispute.
Thank you, Counsel. You have time on rebuttal.
Thank you.
Sorry. May it please the court, my name is Catherine Bolger from Davis Wright Tremaine on behalf of the appellees.
So this is a motion to dismiss pursuant to 3211. Why not let it go forward? I mean, we have the complaint. It is well pleaded, as counsel stated. Why not have it go forward? We'll get discovery, see what's going on, exactly what occurred.
Because the allegations pled in the complaint and the annexed exhibits make it impossible for the plaintiff to ever demonstrate that there was gross responsibility here. So what they have pled is that Bruce Johnson was the source who had firsthand knowledge. What they have pled is that he said it was true at the time he told it to the defendants. What they have
Bruce Johnson?
Sorry, did I say Johnson? Bruce Hay.
Yeah.
I apologize.
It's like, who's Bruce Johnson?
He's that guy I invited over. Sorry, Your Honor. What they have pled is that that Hay said he gave Bolanek and her editors all of the relevant information and documents he could. That included the litigation proceedings from no fewer than 7 litigations, ejectment proceeding, 2 criminal actions created by the plaintiffs, an action that Mr. Hay brought against the plaintiffs, and a whole bunch of other things, including other criminal complaints. All of that information was in the hands of the defendants when they wrote the article. That's what the plaintiffs have pled. They've also pled that there was a Title IX proceeding, and they've pled that the New York Magazine had that, right? They've pled that they had a private
And the Title IX proceeding was ultimately dismissed, right? Or no?
The Title IX proceeding was ultimately decided in favor of Mr. Hay, and it concluded that Ms. Schuman was a liar about these allegations.
But all of these, the information imparted to the publication, the argument still is that they did not engage in the practices they should have engaged in terms of fact-checking, in terms of following up.
It's not totally clear what the allegation is, Your Honor. It is impossible to say that that is not fact-checking, and many courts have dismissed cases on gross irresponsibility grounds with even less of an record. We've cited them in the brief. But here, what the plaintiff has pled the defendants did, an on-the-record source that corroborated it 6 different ways from Sunday and tried to reach out to the plaintiff, established a lack of gross irresponsibility as a matter of law. And more than that, there's been no allegation that the plaintiffs ever once provided the defendants with any evidence whatsoever to contradict that. There is no well-pled allegation that there's evidence out there that contradicts that. The closest the plaintiffs gets is in their complaint at record 37. They say, we sent them some documents, but they never say what those documents are or what they contained. It is clear.
So it's your position that the plaintiffs never provided any documents demonstrating the falsity of the story.
Absolutely, Your Honor. My point is that what the plaintiffs say is the story is wrong, the story is false. But that's not relevant to gross irresponsibility. Gross irresponsibility is what the defendants did. And what the defendants here did was absolutely everything they were supposed to. There's no evidence in the complaint that there was anything contrary to it. And in those circumstances, the plaintiff will never be able to prove that there was actual malice here, and Justice Lattin was correct to dismiss it on gross irresponsibility grounds. I will just say very quickly, Your Honor, this is clearly a matter of public interest. This is an article about a Harvard law professor who got tangled up in a relationship, and the public aspect of that relationship invoked 5 different courts. It involved 3 different families. It involved 3 different people. It involves an indictment of the Title IX system at Harvard University. There's simply no question that this article is anything other than a matter of public concern to which the gross irresponsibility standard applies, and the plaintiff will never be able to show and has simply not pleaded any reason to doubt that gross irresponsibility did not happen here. If there's no further questions, I'll sit, Your Honor.
Thank you.
It is pled, and the facts were, that there was no extortion. The articles say there was extortion. There was not extortion, and there's no evidence that there was extortion. There's nothing to back that up. The article said that they defrauded somebody and pretended they had a lease, and they didn't have a lease. The evidence was that there was a lease. Evidence was given to them that there was a lease. We've pled that evidence was given to them that there was a lease. That's inconsistent with the defamatory claim in the article. We have alleged in the complaint that we provided them with information and documents that showed that the $11,000 that's mentioned was a loan. It was not anything that was defrauded. It was not anything that was extorted. And there's nothing in the record that demonstrates that there was extortion. They claimed extortion in the article. There's no evidence of that, and we pled that. We pled that there was no claim of, there was no harassment. They were alleged to have been harassing people. We demonstrated that that was not so to them, or not we didn't, the plaintiffs did, but we've alleged in the complaint that they demonstrated that there was no harassment and that they went ahead and published it. This was an article that was simply too good to check. And with respect to the fact checkers, first of all, with respect to the second article, there was no fact checking. With respect to the first article, there was a fact checker that called up, was told, and this is in the pleadings, and it is a fact, they were told that the facts were wrong, and they went ahead and published them anyway. So this is all information that we can prove at trial. We can prove at the summary judgment stage. And all we're asking is that we have an opportunity to do that and not be shut out of court because the court below simply accepted hearsay documents in contradiction to what the pleadings were. No court has ruled that you can contradict the pleadings with hearsay documents that are disputed.
Thank you.
Thank you.
Last case for argument, Nostalgic Partners versus the New York Yankees.
Good afternoon, Your Honors. May it please the Court, Joshua Schiller on behalf of the New York Yankees Partnership. The Supreme Court's order should be reversed for 3 principal reasons. First, both parties in this action agreed to be bound by the PBA, which required any disputes to be arbitrated. Secondly, in deciding that the Major League Baseball commissioner was an inappropriate candidate to arbitrate this dispute, the court applied the wrong standard. The court held that the appearance of partiality required the commissioner not to arbitrate the dispute. The actual standard is to present evidence of evident partiality, which was not done. Third, even if the commissioner were disqualified, the appropriate remedy is not to strike the arbitration clause and remove it from the agreement. The remedy is to appoint another arbitrator in that place. This dispute arises directly out of the PBA's expiration. Nostalgia's claim is that they have rights pursuant to a purchase agreement which included a letter agreement with the New York Yankees signed in 2011. When that letter agreement was entered into, both parties were subject to the PBA, a collective bargaining agreement governing all relationships between Major League Baseball teams and minor league baseball teams.
But counsel, the PBA expired.
That's correct, Your Honor.
So why did its provisions as to arbitration continue in effect?
Under the Supreme Court's case in nullity, the expiration of an agreement does not preclude an arbitration provision from applying to a dispute that arises after the expiration. This happens in the context of collective bargaining agreements. It happens in the context of all kinds of disputes, like employment and partnership terminations.
Didn't the 2011 letter agreement amend and restate the documents that existed before it came into effect?
It did, Your Honor, but the PBA was still part of the overall architecture which was in place before 2011, and at the time the 2011 was entered into, and cannot be read in the abstract. In fact, in this Court's prior decision—
Are you speaking of a letter agreement dated August 23rd, 2011? Is that which appears at page 77 of the record?
The letter is dated— Yes, Your Honor.
Okay, so that refers back to a letter dated September 6, 2007, right? So you're saying that this dispute revolves around the August 23, 2011 agreement, and it refers back to the September 6, 2007 agreement. But the September 6, 2007 agreement at page 136 of the record has a paragraph 12, which speaks about jurisdiction, which puts these disputes into court. So how does that provision juxtapose with the other provisions in the professional baseball agreement, the professional development contract, which speak of arbitration? Because if you are tied back to the September 6, 2007 letter agreement, there's no arbitration there.
That's correct, Your Honor, and it's a good question. And first of all, Nostalgic has not sought to enforce the dispute to be litigated pursuant to that provision, which would require any legal action, and I'm reading from it, to be brought in the SDNY or Bronx County. Now, they're unable to enforce that because they have, in fact, waived their right to enforce that jurisdiction provision. However, under the Major League rules, which are incorporated into the professional baseball agreement, which applies to both parties, any agreement that is in conflict with it, which is what this agreement is at the time it was signed, requires the PBA to control, and therefore the PBA's direction that the parties, when either party elects to certify an arbitration, which was done here, the parties must arbitrate. And this Court's prior decision recognized that the PBA is in direct conflict with the merits of this dispute. The PBA and the 2011 agreement appear to give conflicting rights as to the very terms to which Nostalgic can be affiliated with the New York Yankees. That is an issue this Court said was not appropriate to resolve on the CPLR. and is going to be decided and adjudicated here.
Let me just ask you again, I know you answered it, but I don't think I'm clear about it. Why doesn't the September 6, 2007 agreement, letter agreement, have impact over here?
The 2006...
But look, obviously what concerns me is that that contradicts your claim I'm entitled to arbitration because it speaks of going to court. But you say we should not be looking to this. Why?
Because they've waived any argument that they can enforce the jurisdiction provision in that agreement. And the parties are subject to the PBA at the time.
Waiving the jurisdiction, okay, good enough point. Waiving the jurisdiction doesn't mean that you have to go to arbitration yet.
The issue here is whether or not they had a right to extend in perpetuity the right to be affiliated with the Yankees.
The PDC agreement, right? The professional development contract,
That's correct, which is subject to the PBA, which expired in 2020. Now, in order for them to have that right, there must not be a conflict between the PBA and the underlying letter agreement that conveys the rights, because that's what the PBA controls. If there is a conflict, the PBA controls it. And in this case, when it's litigated, the evidence will show that they understood that.
The 2007 agreement is in conflict with the PBA as to the arbitration requirement, and the PBA trumps the 2007 letter agreement. Is that what you're saying?
Both letters are, yeah.
Thank you.
There are a lot of agreements to keep track of here. I said there are a lot of agreements to keep track of here. Well, we have to make our own.
Your Honor, Jim Quinn on behalf of Nostalgic Partners, the respondent. I'll be very brief. The lights are going to go off soon. I understand that. To state the obvious, arbitration is a creature of contract. The Yankees have mentioned many different contracts that have arbitration clauses, two of which they are not parties to.
One of the points Judge Ostrager makes is that, well, you can't go to arbitration here because it involves the commissioner of baseball, and he'd be the arbitrator. So there's obvious conflict, and he can't do it. If that's the problem, isn't the short answer get a different arbitrator?
Well, Your Honor, that would only be the case if you were arbitrating under the PBA. But the PBA, as Your Honor mentioned, expired. The cause of action that raised here came about 2 months after the PBA had expired. They were the ones who let it expire. Okay.
So where does your right? So where does your right? Where does your right to continuing effect of the professional development contract come from? Right. That's what you want.
Yes, that's correct.
Where does your right to that come from?
It comes from the letter agreement. That's the only place it comes from. They made a promise.
Dated what?
They made a promise in the letter agreement that we would.
What's the date of that letter agreement?
Yeah, which letter agreement?
Which letter agreement are you talking about?
The letter agreement of August of 2011. But that agreement wasn't breached until after the PBA.
Which extends the agreement of September 6, 2007.
The one
but your adversary says that that agreement is in conflict with the professional baseball agreement and its requirement for arbitration. And that when you look through that contract, the September 2007 and 2011 agreements have to give way to that professional baseball agreement, in which case you have to go to arbitration.
Only if the PBA was still in effect. It wasn't in effect when the cause of action arose. The cases are very clear, Your Honor.
But doesn't the claim that you have today all arise from these prior contracts?
No, it arises from the letter agreement. That's true, but they breached that promise after the PBA had expired.
So,
therefore, there was no basis to arbitrate, and the letter agreement itself says.
So you mean even though this requirement in the 2007 letter, which said go to court, is not valid because of the professional baseball agreement, which says in the face of conflict, the professional baseball agreement comes first, even though it had that problem when made in 2007, now that the agreement expired in 2020, we don't care about it anymore. And the 2007 agreement, which says nothing about your continuing right to have a professional development contract remain in effect, even though it says nothing about that, you have a right to forget about
Yes, Your Honor, and this court,
professional baseball agement requirement.
this
for
court
arbitration.
in the prior decision said that. They said exactly that. They said that the rights that come out of the letter agreement were not directly related to the PBA. It's in a prior decision in this court.
So, counsel, I'm looking at the 2011 letter agreement, and at paragraph 8, found in the record at page 78, it says that conflicts, in the event of a conflict between the terms and conditions set forth herein, and in either or both of the letter agreements, this letter agreement shall govern and prevail in all respects. So
That's exactly my point, Your Honor. The letter agreement, which has a venue provision in it, which shows that they didn't have any intention to arbitrate, and it wasn't waived in any event. This court also has previously held it wasn't waived.
Where does the August 23rd, 2011 agreement have a venue provision in it?
It's incorporated in the prior letter agreement, the one from
September.
2006.
Thank you.
Thank you.
Your Honors, my friend has said something incorrect. He has said that the claim arose after the expiration of the PBA. The claim arose at the exact same time. The PBA required that when it expired, all affiliations ceased. There were no affiliations as of the date it expired. Your prior decision in this case, Your Honors, says whether there is a conflict between the Yankees covenant in the 2011 agreement and the Major League rules cited by the Yankees, and the effect, if any, of any such conflict are matters that cannot be resolved on this motion. That is at issue, that will be litigated, and that must be arbitrated. It is directly related to the rights and the structure, and if you all decide that to overlook the fact that there is a collective bargaining agreement, which is the same structure that all of the professional leagues in this town have. It is the structure that financial services and other institutions have. It's the same structure that many of the industries like rice and grain and others have, the diamond dealers have. You're going to open the floodgates to all kinds of litigants who simply assert a claim against the form in which they're bound to arbitrate.
The August 2011 agreement, which says in paragraph 8, speaks in the event of a conflict between the terms and conditions set forth herein and either or both of the letter agreements, this letter agreement shall govern. Does it say anything about the professional baseball agreement?
The professional baseball agreement governs all relationships to which the affiliation and the PDC was granted. Without their agreement and their acknowledgement to be bound by the PDA, they never would have received a PDC, they never would have been affiliated. That was required. The process in which they purchased the team was approved by the National Association.
Paragraph 8, giving prominence to the letter agreements, is that it's between the two letter agreements. It's not as between the letter agreements and the professional baseball agreement, is it?
I don't think so, but what I would tell you is that regardless, the jurisdiction provision in that agreement was waived at oral argument. It's in our papers, it's in the record, and it's not being enforced. They sued in a different forum than the chosen forum that was selected in that agreement. And regardless, if they are going to raise these issues, what the law requires is that the arbitrator, in the first instance, decide arbitrability. If they are to argue that there's a conflict that requires one contract to be decided and there's an arbitration provision that they've both agreed to, that is a gateway issue of arbitrability that must be decided, or else you will have every case in here arguing around and pleading artfully around the arbitration provision, and this is not uncommon in terms of how this structure is built upon a collective bargaining structure.
Thank you. Thank you both.
Thank you, Your Honors. Thank you.
Court is over. We have two coming out.